Go ahead and get started. I'm going to call the meeting to order. We're a couple minutes late, not tremendously late, so that's okay. Technical difficulties in the COVID world always seem to present themselves. I appreciate everyone attending today, both people who are here for particular cases, media, and then we've got a number of public. The meeting is actually being live streamed, so it's posted on Facebook and a number of different social media outlets, so everyone keep that in mind. But we've got a lot on the agenda today, so we will try to jump through it. All the commissioners are here, so we obviously have a quorum, and Commissioner Thompson is with us virtually. The first order of business is to adopt and amend the agenda. And Secretary Motti, if you could please enlighten us to some of the amendments that we should consider.
Thank you, Mr. Chairman. There are two amendments to the agenda. The first will be under Category 3 consent orders, letter C, in the matter of Colton Moore. Representative Moore is invoking legislative privilege. He is at a legislative caucus committee meeting, and he intends to show up in person to address the commission in his matter. So that will be moved to the September meeting next month. The second amendment that I would ask be motioned and adopted is under Section 10, Advisory Opinion for Consideration. My understanding is that Representatives Micah Gravely and James Beverly will be calling in for public comment. And so I would ask that we amend to allow for public comment on anyone who has signed up for number 10.
Okay. Thank you, Secretary Motti. And so I will make a motion that we adopt the agenda subject to the amendment that the Representative Moore case is continued, and that I would say the public in general has an opportunity to make comment, including the two representatives that Secretary Motti referenced for the advisory opinion for consideration, if I can get a second.
Second.
So we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. All opposed? All right, the motion carries 5-0. Next, we've got the review and approval of meeting minutes for the June 18, 2020 regular meeting. I hope all the commissioners had an opportunity to take a look at those. Did any of the commissioners have any proposed changes, revisions? Okay, hearing none, I'll make the motion that we adopt the June 18, 2020 regular commission meetings. If I could get a second. All right, we got a motion and a second. I'll call the question. All in favor say aye. Aye. All opposed? All right, the motion carries 5-0. So next we've got consent orders, and the first on the agenda is in the matter of Paul Howard. And who on the commission staff will be presenting that?
I will, Mr. Chairman.
Okay. Secretary Motti, and do we have anyone either virtually or in person for Mr. Paul Howard?
Frank Strickland is on the Zoom on behalf of Mr. Howard.
Okay. Frank, can you hear us okay?
Yes, Mr. Chairman, can you hear me?
We can. All right. Thank you, Mr. Strickland. So, Secretary Motti, if you please go ahead, and then Mr. Strickland will give you an opportunity to make any comment that you have.
Thank you, Mr. Chairman. This matter comes before the commission regarding 5 calendar years worth of personal financial disclosure reports that District Attorney Howard filed, where initially he omitted to disclose certain roles as a fiduciary with nonprofits and certain secondary salaried employment. This came to the attention of the commission following a news story in the AJC and Channel 2 that detailed that District Attorney Howard held a role as a fiduciary, as the CEO of a nonprofit, and was paid a number of dollars in that capacity, but failed to disclose that in his disclosure reports with the commission. In that news report, essentially, the DA Howard confirmed that he held that position. Following that, the commission staff began looking to corroborate whether that was true or not. Factually, and a search and study of IRS tax documents for that nonprofit, as well as a search of the Secretary of State's business corporation records showed that Mr. Howard was the CEO of two separate nonprofits, one from 2015 to 2019 in the relevant time period under the statute of limitations, and the other nonprofit, which was not initially known, from 2016 to 2019. IRS documents also confirmed in calendar years of 2015, 2016, and 2017 that the district attorney was paid by the nonprofit in his capacity as CEO $50,000, $20,000, and $70,000 respectively. So a complaint was filed. Ultimately, additional documents were obtained from that nonprofit that showed he was paid a salary with the initial nonprofit, which is People Partnering for Progress. That he was salaried in 2018 and 2019's calendar years as well. So two additional allegations were filed. At that point, DA Howard, through his attorney, Mr. Strickland, filed amended reports, disclosed those roles and that secondary employment. And essentially in those PFDS reports, you have to disclose if you hold a position of fiduciary trust in any profit or nonprofit corporation. And that's in section 2 of that report. In section 5 of that report, you have to list any secondary employment. And at that time, as I mentioned, through his attorney, Mr. Strickland, they amended those reports and disclosed all of those roles and capacities. District Attorney Howard has agreed to pay a fine and admit to those violations, and he's agreed to pay a fine of $6,500, which is a figure that was calculated per violation within precedent, within the norms of our ranges. And so I would ask the commission to accept the consent order for the, as it says in the conclusions, a fiduciary position in the 2015 calendar year, as well as secondary employment, and then in 2016, 17, 18, and 19, failing to disclose two fiduciary positions in secondary employment in those respective reports, and agreeing to pay a civil penalty in the amount of $6,500.
Okay, thank you, Secretary Abadi. And Mr. Strickland, do you have any additional comment? And I think you're muted, Mr. Strickland. You're muted, so you'll have to unmute for us to hear you.
Can you hear me now, Mr. Chairman?
We can.
The sound is a little bit rough at this end. There's a lot of chatter in the sound, so it's very hard to hear on this side of it. We're satisfied with the terms of the consent order, and I don't think anything else needs to be said about it. Mr. Amati's summary of the consent order is accurate, and it's already been signed by Mr. Howard and by me, and as far as we're concerned, we're ready for it to go forward.
Okay. Thank you, Mr. Strickland. Any commissioners have any questions? What do these nonprofits do?
I really don't know, Mr. Chairman. I'm going to be careful about getting too detailed because there are other elements at play here, and I don't want to speak out of turn or beyond the scope of what this commission does. But my understanding was that one of the nonprofits was to reduce youth crime. I'm not sure what the other nonprofit was purposed for, but I don't have much information in that regard.
Okay. All right. Well, as long as Mr. Strickland and Mr. Howard are in agreement with it, and it looks like Mr. Howard and I think Mr. Strickland have already signed this consent order, I have no objection. I don't know if any of the commissioners have any questions. If they don't, I will make the motion that we adopt the consent order as proposed in the matter of Paul Howard.
Second.
Okay, we've got a motion, we've got a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? We heard you, Commissioner Thompson, that time. Good. Okay, so motion carries 5-0. Now Next on the agenda is in the matter of Mary Norwood, and who on behalf of the commission staff will be presenting that one.
I will, Mr. Chairman.
Okay.
This matter comes before the commission, case number 2017
And I'm sorry about that. Is anyone here on behalf of Ms. Norwood, either virtually or in person?
Mr. Strickland is.
Okay.
This matter comes before the commission on case number 2017-0233. Ms. Norwood was a candidate for mayor in the 2017 mayoral election cycle in the city of Atlanta. At some point following the mayoral race, and this predates my tenure, and I think it predates everyone on the commission's tenure with the commission, but the commission asked staff to audit all of the candidates in the mayoral race. Some of those candidates you've already heard cases on, some you haven't. But ultimately, an audit was done on Ms. Norwood's campaign accounts. Discrepancies were found about the amount of, about two issues. One, the amount of money that exceeded maximum contribution limits from a number of donors. And you'll see in the findings of fact that there are two sections. And the other was, there's a CUSA, which is a way to accept money for both a primary and a runoff, a primary and a general runoffs, as well as that prior to the runoff, as long as you separately account for those contributions and put those buckets of money in different areas where you can spend it. And Ms. Norwood did not file that CUSA document, and so there was a bucket of contributions that exceeded maximum contribution limits because had she filed a CUSA, those contributions would have been permissible. But because she did not file them, it was illegal to take them at that point. Bank accounts for her campaign were subpoenaed. We reconciled those bank accounts against the filings, and there were a number of initial filings that were incorrect that lowered the amount that exceeded contribution limits. And ultimately, as you'll see in the consent order, Ms. Norwood is admitting to improperly accepting $58,300 in contributions by not filing the CUSA. So those contributions were improper, but had a CUSA been filed, they would have been legal. And then she's admitting to improperly accepting $22,450 in contributions that flatly exceeded the legal limit. And so as a result of those admissions, she has agreed to pay a fine in the amount of $27,000 in civil penalties. And I would ask the commission to accept that consent order as well. And I know Mr. Strickland represents Ms. Norwood in that case.
Okay. Thank you, Secretary Amati. And Mr. Strickland, do you have any comment for the Ms. Norwood matter?
Mr. Chairman, am I off mute?
Yeah, we can hear you.
Okay, fine. Again, we're satisfied with the provisions of the consent order. I would point out that Ms. Norwood had over 4,000 contributions and raised over $2 million, and this is although slightly over the limits. She's a meticulous record keeper and was very much upset by the fact that there was some mistakes in her record keeping, but all the reports have been amended, and she's agreed to pay the penalty, and we're ready to go forward with the order. And if I may make a couple of other comments, I want to compliment the professionalism of the commission staff. We dealt with the executive director, the deputy, and senior staff attorney Joe Cusack. There was a high level of professionalism, which I think did not exist with previous commissions. So I compliment the commission and its professional staff in all respects.
Thank you, Mr. Strickland. We appreciate that. We take great pride in the commission staff and agree that they do a good job, and we appreciate you working with them in reaching this agreement. Do any of the commissioners have any questions for Secretary Amati or Mr. Strickland? Okay. Well, as long as Mr. Strickland and Ms. Norwood are okay with this consent order, I am as well, so I'll make a motion that we adopt the proposed consent order as stated in the matter of Mary Norwood, if I can get a second.
Second.
All right, we've got a motion, we got a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, carries 5-0. In the matter of Colton Moore, that's the one that we continued pursuant to the amended agenda. Next is 2019-0064 in the matter of Mary Line Blackburn. And who on behalf of the commission? Mr. Cusack?
I will, Mr. Chair.
Okay. And is anyone here on behalf of Ms. Blackburn?
Ms. Blackburn's actually here.
Okay, great. And we'll give you an opportunity too, Ms. Blackburn. Thank you for coming.
Mr. Chair, this is case number 2019-0064 in the matter of Marilyn Blackburn. This was a third-party complaint that came in that was filed by William Perry on October 28, 2019. And what it alleged was that Ms. Blackburn, who ran in a special election when a seat was vacated on the Smyrna City Council, she ran as the Ward 3 councilwoman, that she did not file a report in a special election runoff. So there was a special election. She was one of the top 2 vote getters. That went to a special election runoff, which was held on December, I believe, it should be held in December 5th of 2017. So there was an election of November 5th, in November, and that went to December 5th, 2017, special election runoff. So she had to file a campaign contribution disclosure report 6 days prior to that, and that was not filed. So that was the complaint. There was also an allegation that some 2-day reports were not filed. However, those were properly filed after the fact. She also went back, so it's a strange provision in that there's 6 days before, so it ran up against that timeline of December 5th, there needed to be a filing, but also December 31st, there needed to be a filing. So she made that December 31st filing and disclosed all those disclosures, or disclosed all the contributions and expenditures that should have been on that 6 day prior to December 5th runoff campaign contribution disclosure report. So there was no intent to hide anything. She was above board on that. It was just a failure to file that 6 day prior to the runoff CCDR. So she has agreed to pay a civil penalty in the amount of $125 for a failure to file that one CCDR in violation of 21-534. So I would ask the commission to accept that. And Ms. Blackburn is here as well.
All right, thank you, Mr. Cusack. And Ms. Blackburn, do you want to make a comment?
No, thank you.
You don't? Okay. Well, thank you for coming. Do any of the commissioners have any questions? All right, hearing none. I'm good with it. You good with it, Ms. Blackburn?
Oh, absolutely.
Okay, get to put this behind you. Good. Well, as long as you're good with it, I'm good with it, and I'll make the motion that we adopt the proposed consent order. Is it Mary Line or Mary Line Blackburn? If I can get a second. All right, we got a motion. We got a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, the consent order is adopted unanimously. Thank you. And so next up, we've got in the matter of Mark Urbach, and who on behalf of the commission? Is that you as well, Mr. Cusack?
Yes, sir,
okay,
Mr. Chair.
Go ahead. And is anyone here on behalf of Mr. Urbach?
I don't believe anyone will be here for that.
Okay.
This is a matter of Mark Urbach. This is case 2018-0012. And commissioners, if you'll remember, in the December meeting of last year, we found there was reasonable grounds to perceive that a violation of the act had occurred. After that occurred, his lawyer entered into negotiations. We were able to hammer this consent order out within that 30-day window, which we were able to. So this came in as a third-party complaint filed by Mark and Patricia Zeller on February 13th, 2018. Mr. Urbach was a candidate for governor during the 2018 election cycle. He announced he was going to run and then withdrew from the election on May 1st of 2018 and raised a grand total of $4,350 in total contributions during his time he was running for governor. 4,180 of those total contributions were in a loan given to himself, and $150 in a contribution from a single source or single donor was what he raised in actual outside money from not from him. He has agreed, he missed a lot of the, I guess, CCDR reports, June 30, 2018, September 30, 2018, October 25th, 2018, December 31st, 2018. And I brought up some mitigating facts the commission was aware of. And I know Commissioner Watts said during that hearing, keep those to ourselves, and that's something the commission takes into account. I'm not going to get into anybody's business, but there were some mitigating facts that his lawyer was able to provide me in terms of documentation. So that's why the fine is $125 in this case to settle this matter. So there was some facts that I took into account, used some discretion in order to close this case and let Mr. Urbach get on with his life. So all those violations, for violations 21.534 for failing to disclose or failing to file those campaign contribution disclosure reports. So I'd ask the commission to adopt this consent order.
Okay. So he raised 4350 total and loaned 4180 for governor.
Yes,
Okay.
wasn't the biggest campaign.
Is that you, Commissioner Cranville? Go ahead.
I just was more curious about this than anything. It always gets my attention when we get a consent order after a finding of reasonable grounds, and so I just always like to ask, first of all, when, if you know, did Mr. Urbach engage an attorney in this, and why was it, why did it take the finding of reasonable grounds before he was willing to enter negotiations with you?
So he had an attorney from the beginning. It was an attorney he had for a divorce. So we weren't dealing with someone who is normally in this realm. The case had been continued twice off of other calendars to that December calendar. So finally it became, hey, we're not letting this keep going. We're going to do the hearing. You're on notice. He chose not to be here. And he was in the process of getting me some documents to sort of prove up those mitigating facts he was going to give me so I could ultimately make a call on what the fine structure would be. And after the hearing, he was able to give me those. He's trying to communicate with his client to get him those. So I think there was a client-attorney breakdown in communication there. So once he was able to get those, I was able to be comfortable making the offer to I guess, resolve the case in this manner.
Because my recollection was that when we found reasonable grounds, no one appeared on their behalf, right?
That's correct.
Okay.
All right. Any other questions? Okay. Hearing none, I'll make the motion. We adopt the proposed consent order for in the matter of Mark Urbach. If I get a second. Okay, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, the motion carries unanimously. Yep. On the line, okay. So next we've got in the matter of Lance Lawyer Hammonds, and who on behalf of the commission is presenting that one?
I am.
Okay, Ms. Browder, whenever you're ready. And is anyone here virtually in person for Mr. Hammonds? All right, go ahead, Ms. Browder.
Okay, so Clark Hood filed a third-party complaint back on May 15th, 2018 against Mr. Hammonds, alleging that Mr. Hammonds had not filed any of the required forms for a candidate for public office. Mr. Hammonds was a candidate for the school board in DeKalb County, District 6. He was unsuccessful, but the main issue in her allegations were that he was collecting funds and had not properly filed CCDRs, and that he had also not filed the PSPS. Mr. Hammond had actually timely filed all of the CCDRs that were required to that point, but he did not timely file the PSPS. And we did not receive a copy of the PSPS once he did file it from the DeKalb Voter Registration and Elections Office. But that was filed late. It was due within 15 days of him qualifying, which was March 17th, and he didn't file it until later on in April. When the commission assessed late fees for Mr. Hammond, the late fees were not assessed for the late PSPS, and they were not assessed for his campaign for the Board of Education. The commission assessed late fees for a January 31st, 2018 CCDR and a financial, I'm sorry, I'm saying that incorrectly. The commission assessed late fees for a January 31st 2018 CCDR, and also for a public financial, personal financial disclosure statement being late. And previously I spoke incorrectly, but he filed a CCDR late, I believe, and it wasn't the issue of the PSDS. The situation here is that Mr. Hammond, once he was assessed to late fees, he was assessed late fees saying that he had run for the Cobb County Commission, which he was not a candidate for, and the January 31st, 2018 CCDR was not required because he didn't qualify until May, and another late fee was assessed for a financial disclosure statement that was not due because he was running for a local office and he wasn't currently serving as a public officer. Nevertheless, once those late fees were assessed, Mr. Hammond sent in checks to pay both late fees, and they were essentially paid for what they were documented for. But what the commission did not do was assess a late fee for the document and election that was actually at issue. His March 31st UCDR was late and should have been assessed or incurred a late fee of $125. He did incur late fees that he technically did not owe, and he paid them, which were $250. And so, in this consent order, we proposed that Mr. Hammond allow the commission to reallocate the funds that he paid for late fees that were incorrectly assessed, which would be $250 going towards whatever late fees he actually owed, and he only owed $125 in late fees, and so that would result in the commission owing Mr. Hammond a refund for $125. Mr. Hammond was in agreement with that, and so I'm just here asking on behalf of the staff that the commission allow us to enter into this consent agreement, refunding $125 and also reallocating $125 from a late fee from the late fees that he previously paid that were assessed incorrectly.
Okay, thank you, Ms. Browder. And everyone, if you're not speaking on Zoom, make sure to mute your phones. We want to reduce any feedback, so make sure if you're not speaking, you mute your phones. The one question I have is this one is not signed, so I just want to make sure that, is yours signed? Okay, oh, maybe it's the folder. Okay, never mind. The one I'm looking at digitally is not signed.
Right, so there was no signed copy when the binder was created, so Mr. Hammond, I believe, overnight his consent order and was received earlier this week, and so I believe Ms. Easton has it.
Okay, good. Commissioners have any questions? Okay, well, hearing none, I will make the motion that we adopt the consent order in the matter of Lance Lawyer Hammonds. If I can get a second. Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, the motion passes unanimously. So next we've got the extraordinary motion for reconsideration in the matter of Michael Julian Bond. I hope we have a deal. I hope we have a deal. Hopefully you guys are going to bring good news. And
You don't want to hear from me again?
every meeting, right? Okay, well, and it Miss Little, right? Is that who's representing Mr. Bond?
It is.
Okay, well, go ahead whenever you're ready.
I do believe that we have a deal worked out. We worked hard to come up with something that we felt was achievable and that got the fine paid back to you guys in the quickest time period as possible. We did not understand that there was the option of utilizing campaign funds to pay a portion of this. And so we have structured an agreement that reflects a lump sum payment up front, monthly payments, and then additional lump sum payments next year. And the reason being because some of this will need to be paid screws the use of campaign funds, and he will need time, to be able to raise those. So the agreement that we worked out, is a $5,000 payment now, $200 a month for the months of August, September, October, November, and December of 2020. That will provide a total amount of $6,000 in payments for the year 2020. The schedule in 2021 would be $400 a month for January, February, March, April, and May. Again, July, August, September, October, and November. So each of those 10 months, you would be paying $400 a month. We would have a lump sum in June 2021 of $7,200 and a lump sum in December 2021 of $16,500. That would be a total fine amount of total fine payment of $27,700 just in the year 2021. That leaves about $5,200 left. So that is the way that we structured this was to try and get all but 10% paid within, about 16, 17 months. So within 17 months, you guys will have the entirety of the total fine amount of $45,000 less about 10%. After that time, for obvious reasons, it's going to be difficult for him to sort of raise any campaign funds. And so at that point, we would go back down to $220 a month for 24 months. And that would close out the entire amount. Now, when we had come before, we explained not only his, health conditions, but also his big personal financial situation and the fact that he has about $200 a month disposable income. His rent actually went up. We just found out within the last couple of days. It went up about $100 a month. So that disposable income amount has decreased. Over the course of the next few years, though, some of those loans that we had initially discussed with these guys, I believe will be paid off. I think only one will be paid off by then. But we're working with him in ways to be able to ensure that even after that campaign cycle in 2021, that he is able to make those $220 payments a month following that. We had discussed, the constitutional issues with regard to the fine amount. If you recall, this was a $45,000 total fine, which was the largest in the history of the commission. And this settlement agreement does not reflect any overall reduction in that fine amount. I want to make that clear. We've not asked for the total $45,000 to be reduced. We are just asking for this schedule because it's something that we believe we can absolutely accomplish, within the parameters that we've discussed, and now that we have the understanding of how these fines may be paid, at least in part.
Okay, thank you, Ms. Lowell, and Mr. Lane, I'll let you speak as well. And the first question is the same question we talked about last time, which is, and I want to make sure the commission has the authority to do what we're being requested to do. There's already a consent order which has been agreed to, it's been entered. Are you guys requesting we amend it? I mean, what exactly are we being requested to do, and do we have the authority to do it?
Mr. Chairman, thank you. Commission staff is not asking you to amend your prior order, the consent order that was entered many years ago. To answer your question about the authority of the commission does not have the authority under the Administrative Procedures Act, under the Campaign Finance Act, or under its comprehensive rules and regulations. It does not have the authority to reconsider, amend, or set aside its prior order. If the commission wanted that authority, we'd be able to proclamate a comprehensive rule and regulation setting out a procedure for you to do that. But since none exists, you can't amend that order. What we're asking, and Ms. Little is correct in the payment schedule that we've discussed. What we have basically agreed to with Mr. Bond is, for lack of a better term, a gentleman's agreement, that the commission staff will not seek the issuance of a 5-pay from Superior Court to begin garnishing Mr. Bond's wages unless he misses a payment under this new schedule. My understanding of the agreement is that if Mr. Bond is late on any of these payments, commission staff will then seek to have the Superior Court issue a 5-pay, which this commission does have the authority to do under, I believe it's 2156 subsection B14. The commission staff has the authority to basically have the commission issue a certification to Superior Court that there's a money judgment due and owing, and a 5-pay issues immediately to allow garnishment proceedings to begin. So what we're simply saying and what we're asking is that the commission deny Mr. Bond's extraordinary motion for reconsideration. The grounds for denial being that the commission lacks the statutory authority, and of course you're a regulatory body, so you don't have power of equity. You lack the authority to amend your order, and then basically we're asking for your blessing to approve our gentleman's agreement where we will not seek the issuance of a 5-pay, allow Mr. Bond the opportunity to carry out his payment plan as he has laid out, and then we will only seek a 5-pay if he defaults under the terms of the agreement that he's entering with us now. I hope I answered the question.
And Commissioner Barnum?
Yes, Mr. Lane.
Yes, sir.
Does the general person's agreement that you outlined include any type of notice of violation and cure period? Meaning, if he misses a payment, does the agreement require that the commission give him notice, and then Mr. Bond has an opportunity to cure before the commission staff seeks the 5-pay?
Currently, there is not, but if the commission would like a notice and cure period, that's perfectly acceptable to commission staff. The general standard cure period that we do within our consent orders, there's our standard language is that we provide notice upon default. And if default is not cured within 15 days, an acceleration clause goes into effect and the amount is due and payable in full within the next 30 days.
Thank you. And Mr. Chairman, I don't have a particular view of that. I wanted to be clear, if there is a cure period, what the terms of that period might be, and if there isn't, and then Ms. Little, I hope you can hear me on behalf of your client, that your client understands that the commission will seek a 5-pay without any option to cure, so that we can avoid being here 4 years from now on an extraordinary relief for extraordinary relief from extraordinary relief.
Yep. And Secretary Marty?
So I want to make a couple points. I think I need to make a couple points. I'll start with what Commissioner Barnum just raised. I'm not in support of a cure period. I think we have gone above and beyond, and doing this, I think, and Ms. Little can correct me if I'm wrong, but when we talked, I think we said, look, if he's a day late, we're moving forward. We're extending a lot of grace here. And so I'm not in favor of any mechanism for a cure period like that. I do need to point out, I agree with Mr. Lane, there's no mechanism to reopen an old case. This commission would have to promulgate a rule that would allow for that. And I'm not going to get all the way in the weeds on whether I like or dislike that idea, but that would have to happen. I think I'm compelled to point out that at our last hearing, the staff, at my direction, opposed any amendment to the pay schedule. And we were asked as staff to come back with an alternative. This is the best alternative that I think we all agree will work. If the commission feels it's not adequate, we need to know that and we'll move forward. If the commission feels this is adequate, we will allow this to move forward as long as he is compliant with this schedule. But I'm not, and I credit Ms. Little for not seeking to reduce the fine because I'm not in favor of unlitigating litigated cases. But this is sort of the commission's opportunity to give us direction about how you want us to proceed and we can go from there. But this is something we opposed in June And this is the best alternative option towards actual collecting. And I think it was Commissioner Barnum who made the point of a bird in the hand is better than two in the bush. So this is that alternative, if the commission wants us to pursue in that direction.
Commissioner Watts?
Yeah, two questions. First off, and just in the terms of the deal, is this with interest or without interest?
Currently without statutory interest.
Okay. And then, Mr. Amati or Mr. Lane, is there a specific bar in the statute from the commission reconsidering a previous order?
There is no specific declaration that the commission shall not consider its order. It is simply that when you look at motions to set aside and motions for reconsideration, the commission cannot invoke the terms of the Civil Practice Act, which is where you see the extraordinary relief in a civil proceeding. Additionally, when you look at the case law on administrative law, the commission, of course, is governed by its Enabling Act, the Campaign Finance Act, its promulgated rules and regulations which it is authorized to adopt. And then the Administrative Procedures Act is our default floor. Nowhere contained in any of those three legal codes is the power of the commission to reconsider its order. The way the law currently reads is once the commission adopts its final order, the only relief that is available that is discussed within any of those three enabling laws is under the Administrative Procedures Act for relief or judicial relief from an adverse agency decision, which provides the respondent only with the right to appeal to Superior Court an adverse agency decision. There's a number of case law that states that that right applies only to the respondent, not to the commission. The rationale being the commission would never appeal its own decision. So that's the only currently extraordinary relief detailed within any of our three laws.
All right, Commissioner Cranville?
First, sort of on that same subject, I don't think that we should ever get in the practice of overturning or otherwise amending consent orders, adopted by previous commissions. That could turn into a never-ending process where we just start opening, consent orders that have been closed for, 5 to 10 years because we haven't been able to collect on them. Second, and I believe that Mr. Lane addressed this, and I just wanted to make sure that I'm sort of with you on this, is that I'm looking at the request that was made here. It was a very narrow request that was made. It was a request to reopen the case on the basis of undue hardship. And I think that we made clear at the last meeting that we don't have the statutory authority at this juncture of the case to consider a hardship application on a consent order accepted by a prior commission and agreed to by a public officer. I believe that collection matters are for the staff after the consent order has been passed. I am very reluctant to get into business, as a commission of giving blessings one way or the other on, these types of collection efforts. Again, I don't see anything in the code that says that the question should come back to us on that. And so, there may be, an agreement between the staff office not to file a 5A if the terms of this agreement are abided by. But I don't think that it takes action by the commission, and I don't think it should take action by the commission. I don't think that we should put our stamp of approval on something where someone agreed to make a payment over a certain period of time and they didn't make the payment. And so I'm not in favor of the commission taking this action.
Commissioner Barnum?
Sure. I just want to offer one thought to the commissioner's comments. We're the commission. We're not a previous commission or a successor commission. The commission is an ongoing entity, just like a court of appeals and an appellate court, the Supreme Court. I'm not suggesting that our authority is as far-reaching. While the composition of the commission may change, we're a commission, and I don't believe that we would be undoing the work of a previous commission. We simply be, if we choose to, speaking to the work of the commission. So I just want to make sure that I at least offer my view of this body as a continuing body, made up of successive commissioners, but we're not a successor or a previous commission.
Okay. And Commissioner Thompson, do you have any comment? Are you there?
I'm here. Can you hear me okay?
We can. Go ahead.
Yeah. I don't believe we should even be addressing this. It's already been adjudicated by the commission previously. I understand there may have been some hardships, but I just don't think we should get in the role where we continually keep addressing things that we've addressed in the past, either whether it's this commission or a previous commission.
Okay, thank you, Commissioner Thompson. So I'll present this question to you, Mr. Lane, and then Ms. Little, if you have comment, it's a narrow question. I just want you to comment on this question. What is the commission being asked to do?
Commission staff would ask the commission to pass a motion denying Mr. Vaughn's extraordinary motion for reconsideration.
Okay, and Ms. Little, what are you asking the commission to do?
I mean, that's a good question, just because of the way that we've gotten here. After the hearing last time, we sort of discussed, you guys go and work it out. So we did that, we took the direction, we worked it out. I personally was not under the impression that it was necessary to come back to you guys to get this agreement ratified, so to speak. But that was my understanding from commission staff that's what, you know, we were here to do today. And so, put simply, I would say either do nothing and let us move forward with this gentleman's agreement, or, you know, ratify the agreement that we were told to go and make, which we did.
Okay. Commissioner Barney?
Yes, Ms. Little, this is Commissioner Eric Farman. I want to make sure, and can you hear me okay? I'm wearing a mask. I can take it off if you need me to.
I can.
Okay. I just want to make sure that you're clear on behalf of your client that the commission staff is not asking us to ratify your gentleperson's agreement. They're asking us to deny your client's motion for extraordinary relief and reconsideration. And I want to make sure that if we take that position, that the agreement that you've reached with commission staff is an agreement that is, for lack of a better term, a side agreement, that this commission is not being asked to enforce. And so any failure to comply with that agreement will not come back to this commission for enforcement or for extraordinary relief, that your motion for extraordinary relief is being denied or will be denied if we take that position, and then your client will be asked and expected to adhere to an agreement made with the commission staff that has not been ratified nor is being sought to be enforced by this commission. And so while I think it's clear, I'm hoping that you also believe that that's clear and that that is the understanding of your client.
All right, Commissioner Granville?
And Ms.
Well, Ms. Little, if you have a response, go ahead.
You know, so I mean, none of this is completely clear, and my client was trying to get there this morning, although he's being contact traced by the county, and they informed him they had set up a COVID test for him this morning that he needed to go to, and so he was unable to be present there today, and we apologize for that. He tried very hard to get there. I mean, I guess it's somewhat confusing for me, maybe not confusing, that's not the right word, but we made this motion basically asking for the commission to reconsider the payment schedule, and sort of work with us on that. When we got there last time, there was discussion back and forth with regard to the ultimate authority of the commission to sort of restructure that, and it was, you know, clear to everyone that for a variety of reasons, it would be easier if we could just go negotiate this and not ask for a complete amendment. There were issues with setting a precedent. You know, I understand all of the concerns, you know, from your perspective. So with that in mind, we came back to the table thinking, yes, this would be a secondary agreement, / consent order of sorts, that would be, for lack of a better term, enforceable, meaning you couldn't just back out of this agreement, but neither could we. So yes, if we fail to pay, we understand these parameters, we understand what happens next. But we also want some sort of teeth to it that, if staff changes, that, this doesn't just go up in the air.
Commissioner Cranville, you have a comment?
Yeah, what I was gonna say it was to follow what Commissioner Barnum had mentioned. He had said that, with the motion to deny, the proposed motion to deny the extraordinary motion for reconsideration, that we weren't being asked to enforce any side agreement. I just want to make clear that we're not being asked to enforce a side agreement or endorse a side agreement.
All right, Commissioner Watts?
I just want to go back to the enforceability question that's a little just raised. I mean, this is a consent order, right? I mean, is that what y'all have entered into?
Yes, sir.
So this is
It's a side agreement.
This is just a side agreement to a previous consent order.
Correct.
Okay. Yeah, well, I mean, so whatever enforceability it has, it has. But I'm with everybody here. It's not for us to decide as a commission. So my motion would be to deny the motion for reconsideration, move along.
I'll second.
All right, we got a motion, and a second, and I'll make one comment, and just to provide some type of clarity, Ms. Little, because I know it is somewhat confusing, and we get a lot of confusing things before us. At the end of the day, there was an entered and binding consent agreement. You filed an extraordinary motion to adjust that. There's questions on whether the commission has authority to do it. I think sometimes through the process we find clarity, and the clarity in that is that the best resolution was for you guys to kind of work through what's the best way for Mr. Bond to meet his obligations in a way that doesn't unduly impose a hardship on him. I think you guys have done that. I think the commissioners operated in a mediator role through this process, but I think it helped you guys reach an agreement. I will say this agreement is eerily similar to the last agreement, which is there's a lot of small payments and a big payment at the end. And so just make sure, and this is me operating in a mediator role and not a binding authoritarian role, but make sure Mr. Bond is aware of that and make sure that he's comfortable with that, because if he doesn't make a payment, they're going to be able to issue an acceleration of the full amount, and then he's going to be pursuing a FIFA. I think Mr. Bonds went through a unique situation and has faced a lot of hardship, and I think the commission was sympathetic to that. I think that's why the commission encouraged you to talk through it, because otherwise the commissioners could have just denied it, and you would have been facing, Mr. Bond would have been facing a legal action. So I just say all that to say, I think there is some clarity, but I think you guys worked it out, and it's the best result for everyone, including the commissioners.
Mr. Chairman, can I say one more thing?
Sure.
So we do, I mean, setting aside the conversation about the
Yeah,
authority.
hold on one second. Make sure everyone's muted their phone. I think someone's speaking. Go ahead, Commissioner Wong.
So setting aside the policy the discussion we were having about the authority for whether we can reconsider a motion, I do, again, if someone comes here with a consent order that you've agreed to with the staff, we expect you to pay it. And we expect you to we expect you to abide by the terms that you agreed to. What happened here is, again, perhaps a mediator's role, but it shouldn't be precedent setting. And I think that, I certainly, my view, and I think others may hold the same view, is that if you do make an agreement, especially if you're represented by counsel, we expect you to abide by the agreement.
All right, good. Well, we've got the motion. We've got a second. Any other discussion? Hearing none, I will call the question. All in favor of the motion to deny Mr. Michael Julian Bond's extraordinary motion, say aye. Aye.
Aye.
All opposed? Hearing none, the motion carries 5-0. So next on the agenda, and we'll get through this one, and then we'll take a brief recess, motion for attorney's fees in the matter of Joshua McLaurin.
And, Mr. Chair, for Black, I'll handle this on behalf of commission staff, but I think this is more of me just setting the table of what's occurred
Okay.
and letting the parties lay out their arguments to the commission. But this is case 2018-0016 in the matter of Joshua McLaurin. As many of y'all can remember, last month, or in the June 18th meeting, the commission granted the commission's motion, or commission staff's motion for a motion to dismiss on this case. There was a question of frivolousness versus attorney's fees, and there was some discussion. There was a motion made that was ultimately withdrawn for attorney's fees. So as of right now, Mr. Tyson has filed a response in response to attorney's fees. I will say there was a question of notice on behalf of the commission staff, and I will tell the commission there was no notice sent for attorney's fees to Mr. Tyson, because, and I say that because their attorney's fees weren't asked for. So there was nothing for the commission to send in terms of, hey, this is a motion for attorney's fees, because attorney's fees weren't asked for in the response to the pleading by Mr. McLaurin. So there was no notice sent in response to that. I will say Commission Rule 189-2.11 governs on this, which was enacted by this commission. I believe y'all all have a copy of that rule. If not, I have made copies for y'all if anybody needs them. But that would be the rule that governs under this. And if there's no other questions for me, both parties are present.
Yeah, and the one comment I'll make is that if a motion response is ever filed against or in any way affects another litigant, that litigant needs notice. Because the commissioners wasted 30 minutes, maybe more, debating about a motion which one of the litigants didn't have notice for. And so that's not just for you, I mean, that's all litigants. I mean, because otherwise, I mean, I would even argue that's a potential due process violation. I mean, you have to have notice and opportunity to be heard, and so I just want to be very clear, and that's for you too, Secretary Lyon. I mean, litigants need to get notice. Okay, Mr. McLaurin? Oh, Commissioner Cranville, go ahead.
Mr. Kizet, before you sit down, I may have lost you there for a moment.
Okay.
I believe you said that the reason the notice wasn't sent was because there wasn't anything in the response actually requesting attorney's fees.
Correct.
How in the world are we here then? I don't really understand how that, is it just that the question came up at the last meeting, that the request for attorney's fees was made at that point?
Yes.
Okay, so there actually wouldn't have been, I'm not trying to excuse you, I'm just trying to say, I just want to make sure we all understand there was never actually a request for attorney's fees before the last meeting.
That's correct, and it was a request for a finding of frivolousness, and that.
Oh, well,
I still think you need evidence of that.
Okay.
Yes, and I understand that, but I'm trying to say in the context of attorney's fees, there was not notice for specific attorney's fees because there was none asked for. It was a request for a finding of frivolousness.
Right, because if I recall correctly, when we were at the meeting last time, he actually, the way it started was that he said he just wanted a finding of frivolousness, that he wasn't actually asking for attorney's fees, and then it turned into a request for $1,000.
Yes, that's correct.
All right. Now, here's my question, and I'm gonna let them talk about this. I just want to I want to make sure that we're clear on this, that is that procedurally proper? Does anyone have a take on that? That request can be made at that juncture of the proceeding?
Now, let's hear argument.
All right.
Mr. McLaurin.
Yes, I think one of the litigants' arguments centers on that point.
Okay.
I'm reading the pleadings.
Let's see, it's still morning. Good morning, everybody. It's good to be here today, and thanks again for hearing the matter. I'd like to start at the top with just a couple observations. The first is that I'm not here today to beat up on one of my constituents. I think I made that clear last time. Roger Wise Jr. is a member of the Roswell Rotary Club, resident of Roswell, was inducted last year to the Georgia Military Veterans Hall of Fame. So I'm not here to try to take any sort of aggressive action against him, nor am I here to malign his purposes. In fact, I think no reasonable person would believe that Mr. Wise sought out the help of Mr. Tyson to allege Mr. Tyson's exact legal theory in order to file the ethics complaint. The reason I'm here is because I believe that this ethics complaint was part and parcel of a political strategy, as I explained at the last meeting, to basically do character assassination through legal process for purposes of a mail program. Now, of course, ultimately that mail program was unsuccessful, but I cannot speak for the commission's priorities, but I would think that this would be a priority of the commission, especially after hearing Mr. Ahmadi's remarks when he took office and the nature of his priorities as in his role. It's important to make sure that people are not using the commission as a political football, and that's my top priority in committing the time, the resources I have to this process. So to address the merits, I think Mr. Tyson's main concern here, well, there are a couple. He's got a procedural concern, he's got his substantive arguments. To start with the procedural concern, my understanding of the regulation, which by the way was adopted February 2nd, 2020, which was over a year after I filed my response with my request for consideration. The thing about that regulation that I think I want to focus the commission's attention on most is that both the commission has the ability to bring a motion and I have the ability to bring a motion. And on its own motion, the commission can pursue attorney's fees under the statute. Now, you know, law school was a while ago, but looking at the structure of the statute, and y'all might correct me if I'm wrong on this, it appears to me that there's a 1 subsection, and then there's a bunch of lettered subparagraphs under that, A through roughly G. And that all of those subparagraphs are under that top 1 bullet. And the way I read that top bullet is that if a respondent requests attorney's fees, then they're subject to the rules that follow. My reading of this regulation is that if the commission moves on its own motion, to pursue attorney's fees under the statute, that none of those specific rules apply. And I think there's a good public policy justification for that. It's that when you, in your capacity as enforcer of the Georgia ethics rules and laws, decide that somebody has stepped far enough out of bounds, you have the ability, unencumbered by the specific procedures regulating private actors' conduct, to impose a necessary sanction. So at the top, I just want to make clear, I think this commission has discretion on its own motion to deal with the situation if it wants. And to speak to the commissioner's concern, there's a chance that if it's solely respondent's motion, that I'm going to trip through a bunch of laser wires, right? I mean, it could very well be that I'm just toast procedurally if the motion is only mine. So I very humbly and respectfully say to the commission, if this is an enforcement priority of yours, I think it is fully appropriate, especially since it is still pending. There was some discussion last time about whether it was procedurally proper to dismiss the complaint before frivolousness. I think the will of the commission was to go ahead and make a finding on the record that it was frivolousness before we wasted our time talking about fees. I don't think anybody here, I mean, I could be wrong, but I don't know that anybody would have contended that it would have been procedurally proper to proceed directly to attorney's fees had there been proper notice last time. So I think for that purpose, and just like this regulation is analogized, if I'm not wrong, after OCGA 9/15/14 in terms of frivolousness, vexatious litigation, and in those cases you have up to 45 days after the final judgment is entered in a matter to seek fees. So I would imagine that the word pending, especially since the commission teed this discussion up specifically last time, I would imagine that pending encompasses the nature of the proceedings that we have today. So all that being said, the substance of this, I don't think, could be more straightforward. I mean, essentially, attorney for Mr. Wise's argument is that if an associate at a law firm works on a pro bono case that the law firm has taken on in an ethics matter, that's a per se ethics violation because the associate's paid by the law firm. My question for counsel is, if a partner at that same law firm takes a draw from the law firm, which is pretty standard compensation structure, that partner is also being compensated by the law firm, so is that a violation? Is that a violation of campaign finance laws according to his interpretation if any staff person or any attorney for an LLP represents somebody pro bono such that it's exempt from contributions and expenditures? And I think the answer to that is clearly no. The statute contemplates that a person, and this is, I believe it's 215319, I think it's the definition of a person. LLC, LLP, group of people, right? It's a very expansive definition of the word person. So plainly under the meaning of the statute, a law firm, an LLP, is a person that can provide personal services. Now, council has a scare hypothetical about, well, what if Walmart, took in millions of dollars in contributions and put out an army of canvassers to go swing an election? It would be completely exempt from the state ethics process. My response to that is, I'm pretty sure that this commission would interpret the statute and regulations in a reasonable way to define personal services as necessary. I mean, I just spitballing here. Personal services, if you had to define it, could mean in kind, the same kind that is normally offered by whatever the organization is. So if it's a law firm, the personal services they can provide pro bono or legal services, right? I mean, that seems like a pretty straightforward interpretation of the statute. But more importantly, council's interpretation violates the plain language of the statute. And so for that reason alone, I think it's legally frivolous. But more so than that, if you look at your regulation on attorney's fees, it doesn't say that the only grounds for frivolousness are legal frivolousness, factual frivolousness. It says including but not limited to. I think this commission has pretty broad discretion under its own rule to decide what the statutory meaning of frivolousness is as long as it's reasonable. In my opinion, a political hit job that uses the commission's time and resources, state agency, for the purposes of, again, character assassination only for the sake of winning elections, to me that qualifies as frivolous. Last note I'll make before I sit down, or take any questions, is council seemed to suggest that Mr. Wise sought him out for this complaint. He used the word conspiracy, maybe a little mockingly, in his response to the attorney's fees motion, as if to suggest that I'm way off base thinking that this was coordinated in some way for this ethics complaint to be tied to the mail program. My question is, how did Ms. Wetzel, Deputy Secretary for the Commission, how did her email granting me a 30-day extension to file my response show up in the very last mailer that I put as an exhibit in my response? Meaning, there are 3 people on that email. I CC'd Mr. Tyson as a courtesy to let him know, even though he was legally no longer party to the case, because it was a matter between me and the commission, as a courtesy, for transparency, I said, I'm going to CC Mr. Tyson, let him know that I'm getting a 30-day extension. Before I know it, however many weeks later, there's mail that has Ms. Wetzel's email granting my extension, CCing Mr. Tyson, printed on the face of the mailer. And it says, my serious ethics charges, the hearing on them has been delayed until after the election. Why is that? Tinfoil hat, right? My question for Mr. Tyson, if I had the ability to ask him, is how did that email get on that mailer? If it's not true that this was coordinated, either an open, I didn't send it to the Georgia GOP, so there's 2 other people who could have. There either was an open records request to find that email in that amount of time, or Mr. Tyson forwarded the email to somebody who had the express intention of putting it on a mailer. That's all I leave the commission with. I'd be happy to answer any questions.
So the one question is, have you filed a motion requesting attorney's fees?
I have not followed the letter of the rule, which again was promulgated after I filed my response, requesting a motion for attorney's fees in my name. That's correct.
Okay. All right, Mr. Tyson.
Good morning. Thank you, commissioners. I think that we kind of have a couple of different points. We talked about the procedural issues, that the lack of a motion as to Representative McLaurin itself, I think, forecloses the ability of the commission to move on the motion portion of the language. Representative McLaurin has raised now the possibility of the commission itself making a finding of attorney's fees. But I think that pushes us, just assuming for the sake of argument that is a possible way for us to follow through, the commission could do that without a kind of detailed notice and opportunity process, which the list of things that must be provided by a respondent when they're requesting attorney's fees, I think is relevant to the notice the commission needs to give to someone against whom attorney's fees are sought. Obviously, I received a notice of this hearing today, but didn't receive notice of a number of the other issues that are listed in what a respondent would have to show the basis for seeking fees. So I think we have an issue in terms of the notice that's provided procedurally, even if we proceed under the concept of the commission can do this on its own motion. But setting that aside, I think as to the merits piece, this is a fascinating issue of how we interpret the Campaign Finance Act. If you proceed with Representative McLaurin's definition, I know he calls my hypothetical a scare hypothetical, but the definition of person in the Act includes a corporation. And so under the interpretation that he advances as his response to Mr. Wise's complaint, a corporation could undertake a dramatic amount of activity on behalf of the candidate and call all of that volunteer by a person. Basically, the corporation itself is a person, it's providing volunteer services. On the approach for a law firm, I think that the line there is clear. If you're a partner at a law firm, you can volunteer your own time on a particular matter for someone. If you are an associate at a law firm, you can volunteer your own time for that. If you are a salaried employee of a law firm and the law firm is volunteering your time and you are being paid, that's a categorically different scenario. And for associates at law firms versus partners, that's a very important distinction. To the last point from Representative McLaurin about kind of the larger issue of how did this appear on a mail piece, obviously I have a client, I represented my client. I did not represent any campaigns that were involved in what was going on here. I can't speak to what may or may not have happened in that scenario. I know that the commission is subject to the Open Records Act, and I honestly do not know how that information would have arrived for the candidate that he was concerned about. But I think we also have a larger question to look at how far do we go in terms of criminalizing campaign activity. I mean, I understand the role of this commission is to look at the proper disclosure and those types of things, but if we're having a back and forth of a campaign and dealing with the charges and counter charges that are made, and that ultimately Representative McLaurin was successful in having convincing the voters that he was the right person for the job, how far do we want to go in criminalizing individuals who are getting involved in that process based on nothing more than an otherwise public record appearing on a mail piece at some point? So I'm happy to answer any questions, but I believe that really solves the issue, Mr. Chairman, in terms of both procedurally. I think we stop there, but even if we go to the substance, I don't see that there's an issue of frivolousness here because it raises significant questions about the proper interpretation of the Campaign Finance Act going forward.
All right, thank you, Mr. Tyson. And Commissioner Barnum?
Mr. Tyson, did you send an email to your client?
I honestly do not remember at this point, nor did I go back and check on that. That is possible that I did.
Thank you.
Well, just clarify.
You can't say for certain that you did not. Is that correct?
That's correct, and I believe if I had gone back and checked, there might even be a privilege issue of me disclosing whether I sent it or not, but I can't answer that question for you standing here. I'm sorry. Thanks.
All right, commissioners, any questions? I think the first thing is I want to focus on the procedural issue, and either, I think Mr. Or Representative McLaurin, maybe you're the best one to answer this, but as I read this, I don't know how we can award attorney's fees if there's not a pending motion. And in section D here, I mean, it makes very clear that the motion's got to be filed and it's got to be served. You made an admission that no motion's been filed. The only alternative to that is that the commission sua sponte makes a motion. That hasn't happened. So procedurally, and I agree with what you said earlier, and I made this statement at the last one, which is the commission should not be, and at no point, at least as me being chair, to the extent I can control it, will we allow the commission to be weaponized, and I think that's something all the commissioners take very seriously, and so we agree with that. But procedurally, I don't know how we can give you what you're seeking if there's no motion.
So, and Mr. Chair, thank you for raising that point. If you recall last time, maybe my face didn't reflect it, but I was a little flummoxed at how to handle the situation, given the posture. It was a confusing procedural posture last time. And I readily acknowledge I never asked for money. I only started asking for money by suggestion once it was considered that, the commission would not pursue a finding of frivolousness unless I sought fees. And so I think we were feeling out as we went, which again, is not a context in which you want to make an award that day because notice is required. So as a member of the bar, I can't stand here today and tell you that if I filed a motion for fees that it would be compliant with this regulation. For the very simple reason, at a minimum, that I did not actually pay somebody else money or expend fees under the meaning of the rule in order to be eligible for fees, right? Or at least that's my professional judgment that I couldn't ask for that. However, I don't want to waste the commission's time. If the commission's not inclined to make its own motion, I'll just go. But I thought that there was some ambiguity as to our last hearing about whether the commission was inclined to bring its own motion for fees. And that's why I'm appearing today, because my reading of the regulation, again, I've got it up on my handy mobile Westlaw, is there's a 1 subsection right under the top, commission shall assess reasonable necessary attorney's fees. That whole paragraph, and immediately beneath it, it says 1, whenever a respondent desires to seek an award of attorney's fees. So I read this as regulating a procedure under which the respondent has filed the motion. I don't read any of the lettered rules that follow as pertaining to the commission's own motions. And so, at the risk of trying to see y'all in September or whenever y'all next meet, I guess my reason for being here today is to encourage the commission to do whatever it feels is procedurally necessary to move sua sponte on its own to award fees pursuant to regulations that it fashions consistent with this rule.
Okay. Secretary Money?
So I think, this is a nuanced area for staff because we're not wading into advocating, but I think there are a few things that I need to say on behalf of staff legally. And I want to start by saying that I'm sympathetic to Representative McLaurin's complaint. And as the representative mentioned, when I took this job, I said, we're not going to allow this to be weaponized, just like the chairman said. So I'm sympathetic to that, if in fact that was the case. The point I will make is this. If you look at 189.2.11, it starts out by saying, the commission shall assess reasonable and necessary attorney's fees and expenses of litigation in any administrative action, and it goes on, related to any pending complaint that is frivolous. So the fundamental structure of this rule is in assessing attorney's fees. And if there are no attorney's fees at issue, setting aside the chairman's point about about a motion being filed, if there are no attorney's fees being sought, I don't believe this rule empowers the commission to make a finding of frivolousness. I think attorney's fees being sought is a fundamental component to this rule. And if that's not the case, then I don't believe this rule is applicable. I will also say that, and again, I want to stress that I'm sympathetic to the representative's arguments and point. And I said this at the last meeting, I don't believe that this was a frivolous motion given the knowledge that the third-party citizen had at the time. Now, is it baseless upon what Representative McLaurin has presented? Absolutely. That's why staff at my direction moved to dismiss it. But what we know and what Representative McLaurin provided for us is not necessarily what a third-party citizen would know at the time of filing a complaint. And I think we run a very dangerous line when we start, to Mr. Tyson's point, when we start criminalizing or monetizing third-party citizens speaking out about something they perceive to be incorrect under the act. That has a chilling effect, and I think it needs to happen when it should happen. We need to be very careful. And so I make those points not to advocate a position, but I think those are things the commission needs to consider, when addressing this vote.
All right. Commissioner Watts?
So, I guess Representative McLaurin, are you relying just on this clause, which is the second line before the one, the commission shall assess reasonable and necessary attorney's fees and expenses of litigation in the administrative action pending before the commission upon the motion of the respondent or the commission itself?
I'm responding on that last part that gives the commission the authority to, and if I may just very briefly, I think it's telling, the regulation feels the need to spend, well, regulations don't feel needs, but the commission felt that it was important to specify in the regulation that attorney's fees could not be assessed unless there was actually money expended. But as I've said a minute ago, that was underneath the if the respondent files category, right? And so I guess my point is, I think it's a reasonable interpretation of the statute. In a world where we don't have a regulation yet, I think it's reasonable to think that the statute authorizes the commission to assess my time as an expense of litigation or as a fee. But in the regulation that the commission chose with respect to respondents' filings, the commission chose not to do it that way. So I guess to respond to the Secretary's point, I don't necessarily see it being predetermined by the statute that the only reasonable reading of the regulation is money expended. And one good public policy reason for this, that the view I have to be the view the commission takes is a lot of these cases you have candidates who don't have great financial means. I mean, you obviously work with the commission, you're very well aware of this. And if you get hit with an ethics complaint like this, sometimes you need well-trained counsel to assist you. And sometimes pro bono representation is the only way to do that. or if you can't afford counsel or can't find counsel, to try and spend your own time and resources defending it yourself. And so I think there is a good public policy justification to impose a cost on a frivolous complaint for the purposes of at least, deterring people from filing complaints against folks who don't have the means to respond adequately.
All right, Commissioner Barnum?
Sure, and Secretary Marty, I'm not sure, who's the staff attorney? Do we have a staff attorney kind of handling this that I can direct the question to, Mr. Cusack? All right, so do you have a thought about Representative McLaurin's position that the commission can sua sponte make a motion to find on a finding of frivolousness. I guess I've got two real issues, because there's a finding on the frivolous question, and then there could be an award of fees. So for example, we could find frivolousness, but award something less than $1,000. But so can you speak to this first, the piece about the commission sua sponte making its own motion?
So I believe the rule allows, can stand up to address you, Commissioner. The rule allows the commission on its own motion to, and I guess you would have to assume that there's attorney's fees. Somebody would be represented by counsel, obviously. Everyone's a lawyer understands that when a lawyer appears on someone's behalf, there's some sort of expense on behalf of that lawyer to be there. So there would have to be a finding or that attorney's fees had incurred. Now, the commission could do that on its own upon seeing the lawyer here, but there's a thorny issue of whether Representative McLaurin would represent himself if there's any attorney's fees there. So I believe, and I'm hoping that answers your question.
It does, because I think what we talked about last time, and I believe I specifically asked Representative McLaurin and clarified that he's a member of the state bar,
Right.
that he does have an hourly rate, and that his time has value. I recall that discussion specifically. Okay.
Now, my question to you would be, would you extend that to a member of the public who files this themselves that is not a member of the bar?
You're right, and right, we could, yes, exactly. Your point's taken, okay. So then, all right, so I think I understand that piece of it, that the staff's position is that we would need to have reached some conclusion that attorney's fees have been expended.
Yes.
To me, that's putting the cart before the horse, because in my view, if a complaint is frivolously filed, whether or not fees have been expended to defend that doesn't change the nature of the complaint in and of itself. If it was frivolous in its very nature, whether or not fees were expended to defend that seems to me irrelevant. And so, you didn't draft the statute, we didn't, so perhaps, we've got it backwards.
And so the commission staff, so the position we've taken on, first you have to have the finding, there has to be attorney's fees, and then it kicks to sort of a two-part test. Was it frivolous, and then what were the attorney's fees expended? And then you have to get to that point. So it'd be sort of a two-part test of whether attorney's fees, just on its own, frivolousness isn't something, as commission staff, we've taken the position that without attorney's fees, there should be no finding of whether it's frivolous or not.
Because at the basis of the motion, it's a motion for fees.
Yes.
And if there are no actual fees, then we don't get to the question of frivolousness. And then we have to, am I understanding the staff's interpretation correctly?
Exactly.
All right, all right, thank you, Mr. Cusack. And Mr. Tyson, a question for you, if you don't mind. I'd like to hear your thoughts about whether or not the commission can sua sponte bring its own motion on this issue. I'd like to hear your thoughts on that.
Certainly, Commissioner. So in just looking at the regulation, it appears to be upon the motion of respondent or the commission itself. So it appears to be that there is a grant of authority of the commission to bring it on its own motion.
Yes.
The concern I would have there then goes to the notice piece at that point of how much notice then is required to the party against whom the fees are being sought.
Well, I mean, you're here. So
I am here, but
you're here and you're making an argument. So I'm not as concerned about the notice because you're here.
Certainly.
You have notice.
I do have notice, but in terms of what notice is required and the opportunity to respond when a respondent makes the motion, there's some very specific things, clear and concise statement of facts, the legal arguments that are there, the amount of fees that are being sought, all of that, and then there's an opportunity to respond by the respondent in a pleading, basically. So I think that we would need to have some sort of structure, but I don't disagree with your interpretation or Representative McLaurin's interpretation that there seems to be some authority of the commission to do this on its own motion in the regulation.
Sure, so you're aware of the legal issues, correct, Mr. Tyson?
Yes, I am.
Right, you're aware of the arguments that Mr. McLaurin has made, correct?
I am,
Okay,
yes.
so on my own motion, assuming I were to make a motion for finding of attorney's fees and frivolousness of your client's complaint, you prepared to make that argument?
I would be prepared to make that argument, yes, sir. We would still probably contest that we had sufficient notice for that purpose on the commission's own motion.
I understand, but
You're prepared, yes, sir.
Okay,
Yes, sir.
all right. Thanks.
Thank you.
You can have a seat, thanks.
All right, Commissioner Watts?
So, remind me, Secretary Molly, did we make any finding last, meeting we had on this case?
It was a motion to dismiss, and you agreed to dismiss it and table this procedural vote. And no finding of frivolousness was made at the last meeting.
All right, and explain to me again why, since now we're just lumping everything together, explain to me why this is not frivolous, this complaint's not frivolous.
So we've gotten so far afield that the underlying facts, I feel like, years ago. But the underlying complaint was about Representative McLaurin not disclosing his campaign reports that he was provided. Representative McLaurin can correct me because I know he's going to be more familiar than anyone in this room. But it dealt with him not disclosing legal representation on behalf of the campaign. And there were dueling issues at the time of a Secretary of State qualifications challenge, which he received pro bono counsel for in the campaign. And ultimately that representation, I believe, was for the qualifications challenge. And had nothing to do with disclosure in the campaign. And in my estimation, I don't know how a layperson, third-party citizen, that's a very nuanced issue that I don't know that, he's a member of the Rotary Club, I don't believe he's a lawyer, I don't know that he would understand that distinction or know the difference.
Which distinction?
That it was Representative Holcomb, correct?
Who was my, Holcomb Award LLP was my counsel.
That they wouldn't, the distinction that the legal counsel was representing him for his qualifications challenge off the ballot, not representing the campaign in any campaign capacity. Did I more or less?
If I may, and tell me, because Mr. Mai, we've spoken about this before, tell me if I mischaracterized what I thought was your position. I thought your position was that you believed it was not frivolous because a person on the face of the proceedings without insider information would not be aware of whether I paid Holcomb.
Right, wouldn't know that we put up.
My response to that is just that in a court of law, if you file an argument that's just flat wrong on the law, even if there is a better theoretical argument that could have been made to support your position, that doesn't get you out of 915-14, in my understanding. I mean, the idea that somebody can file a baseless argument with the commission and they'll hope that the commission finds a more reasonable way of making it, to me does not seem like you can escape the frivolousness charge. Also, I think there's another point that I don't want to get lost, that this was in the matter of me as a person, natural born human being, right? And it was not my campaign that received the services from Holcomb Award LLP. So I understand that there is a tangential benefit to my campaign insofar as me qualifying as but for cause, if you will, of me winning. But there are a lot of things that are but for cause of getting hugs.
Well, let's just say, right now, we don't have a motion.
Right.
Well, yeah, but I mean, I asked the question, so I mean, this is fair. I mean, I brought up the frivolousness question, but my next point was where you're going. I mean,
Go ahead.
if we don't have one from you, a motion from you. We don't have one from the commission. So now I'm looking down the line here.
Well, my understanding was we might have one from the commission. I'm not trying to hide the ball or play games. I was not sure quite what the posture was of this proceeding coming out of our last hearing, because there were a couple putative motions made from the commission during the course of the proceedings. So, I think everyone understood that there was a motion for attorney's fees to be considered, but the source of that motion to me was unclear, to be quite honest with the commission.
Well, there's no motion to my knowledge. I mean, everyone's entitled to make a motion if they want.
Can I recommend making a motion and not make a motion?
I'm about to make the motion.
Okay.
Mr. Chairman. I move that, in the matter of, Josh McLaurin, this case 2018-0116, that I move that we find, in favor of Mr. McLaurin and against Mr. Wise on a request that attorney's fees are warranted under the circumstances on the basis that the complaint filed by Mr. Wise was frivolous, and award attorney's fees in the amount of $1,000.
Mr. Chair, point of order.
Sure.
And I just want to, this is in subsection F of the rule, and this is where this issue might go forward, but subsection F states attorney's fees awarded pursuant to OCGA 2015-6B23 and the applicable rules of the commission shall not exceed the amounts which are reasonable and necessary for defending or asserting the rights of the respondent. Further, no award for attorney's fees shall exceed the actual amount of attorney's fees that were expended by the respondent in the case constituting grounds for the request for attorney's fees. So that's actually in the rule itself. So just to go there, just to make that point.
Okay. Well, we've got a pending motion. Commissioner Barnum can amend it, or the litigants can discuss that and the commission can make a call. So,
And I'm going to keep the motion as is because I'd like to hear the parties' argument and we can get into what does expended mean? Because Mr. McLaurin Representative McLaurin spent that time on his own behalf. I mean, so I'd like to hear the argument. So I'll leave the motion as is, and if we get a second, then we'll have a discussion. If we don't, then we'll move to another item on the agenda.
got it. Well, I am going to have to take a recess. I thought we could get through it, so I'm going to make a secondary motion that we take a temporary adjournment, 5 minutes, and then we will re-adjourn and then hear this motion if I can get a second.
Point of order, Mr. Chairman. There's a pending motion on the floor. So I think we have to deal with the pending motion on the floor before we can consider a different.
Oh, okay, that's right. That's right. We do have to, that's exactly right. So do we have a pending motion? Do we have a second? Okay, well, the motion fails for lack of a second then. So we have still got the pending request for attorney's fees, or for a finding of frivolous, and I'm going to make a motion on that. I will move that we deny the request for finding of frivolous. The basis of my motion is that while I'm fully sympathetic and appreciate Mr. McLaurin making the request, we never want the commission to be weaponized. And we also want these issues to be brought before the commission's attention. I think procedurally it's inadequate because there's no pending motion. And I also think that there's a case or controversy issue in light of the fact you're not requesting attorney's fees. So that is the basis of my motion to deny it. Obviously that is not incorporated into the motion, but I will make the motion to deny the request for a finding of frivolous. Is there a second?
I'm going to second the motion, but for probably a very separate reason. I don't think we should be finding whether something is frivolous or not until we decide whether we're going to move forward with the motion for attorney's fees. I mean, the motion for attorney's fees is what triggers you to find whether the complaint was frivolous or not, in my opinion. And so I don't want to get into the business of just exclaiming that something is frivolous when there's no motion either pending by the commission, which I do believe the regulation gives us the right to do, or by the respondent. But I don't think we should be making a finding without the motion for attorney's fees.
Okay.
So
We got a motion and we got a second.
Mr. Chairman, I guess I'm not sure that was it a second? Because I think the second was a second, but we shouldn't be considering the motion.
So, okay, that's a fair point.
Because if there's no second, then I think the motion dies, as did the previous motion.
Okay, so I withdraw my second.
Okay. Now then we have a request for a finding of frivolous before the commission. And so,
And I think what I'm hearing is the commission is deciding not to take up that request. Because there's been a motion and no second, and so I think the motion dies for lack of a second, and the practical effect is that the commission has decided not to take up that request, which I think the commission has power to do.
well, I mean, I think about if a litigant improperly filed a request, I think the court should rule on the request.
Well, I understand, I guess, but I think, and unless there's some limitations period that the staff can educate us on, there's nothing to suggest that Mrs. McLaurin or some other litigant can't come back and properly file a motion. I think the point that we've heard today is that, at least with respect to the litigant, there is no current motion for fees being brought by the litigant, Mr. McLaurin. And I understand Representative McLaurin, for political reasons, may choose not to do that. But the avenue to do that still exists. Either the litigants may choose not to. The motion's been brought by the commission sua sponte. It dies for lack of a second. And so I think that the commission has decided not to take it up. And until such time as it's properly before the commission, we can move on.
Mr. Chairman, if I could just very briefly, I think an important point, an important limitation, Commissioner, is that the respondent must bring it before the complaint is resolved. And since the motion to dismiss has already been voted on, as I understand it, at the last meeting, there would not be an opportunity for the respondent to then bring an additional motion at this point. If the commission chooses not to take it up, I think the matter is over from a practical perspective.
And it sounds like Representative McLaurin has a response to that. We may have fallen into a political crack, a procedural crack, maybe not.
Well, and I appreciate the Commissioner's comments. I would say it is 100% true that I made a request for a finding of frivolousness from the get-go in the response and have documented that the whole way through. I did suggest to the Commission last time that I think it, contrary to what the Commission staff is saying, that it would be possible to stage the analysis such that you find frivolousness first and then determine whether there are attorney's fees second. I don't think the statute requires an order. And in some ways, this is like the debate.
But are you seeking attorney's fees?
I am seeking attorney's fees. Well, I've already said on the record that I am not seeking
So
fees per se.
in effect, you filed a request for frivolousness, but you're seeking attorney's fees.
Mr. McLaurin, let me see if I can help you out.
Please, Commissioner.
I certainly respect that as an elected official. It may not be in your best interest or the best interest of your constituents to seek legal redress against one of your constituents and to seek fees against one of your constituents. I think I hear you saying that you believe that this commission should make a finding of frivolousness. I have trouble with that word, excuse me. Because you don't want this commission to be weaponized, which, quite frankly, I think it was weaponized against you. I think the complaint was frivolous. I also believe Mr. Johnson had a role in making this complaint, and I'm concerned about his participation in bringing this complaint. I'm troubled by how the email got in a mailer. But if you decide as an elected official that it's not in your best political interest to bring the claim, that's probably just a decision you're going to have to make.
If I may, Mr. Chair, very succinctly try to state what I think my position is. I believe, and part of this has been a response to the evolving conversation. We're all using different terms. We're trying to nail down what we mean. I believe that what I've always had is a motion for attorney's fees as a term of art under the statute. That's the vehicle for what I'm asking for. What I've been asking for is a sequenced analysis where there's a finding of frivolousness first, and then the commission, in its discretion, makes a finding of fact about how many fees I expended, which might involve a legal question. That is my exact ask, and I apologize sincerely if I misspoke earlier to say that I wasn't. When I say I'm not seeking fees, I'm acknowledging, because I'm trying to be honest, that there is a low probability that the commission is going to find that I expended more than $0. But the vehicle for my request has always been the same, which is that under the relevant provision of the statute, I'm seeking, under that relief, that avenue for relief, the commission to proceed down the path of assessing attorney's fees, make a finding of frivolousness, and then find, as a matter of fact, the amount of the attorney's fees expended.
Yeah, but, and the reason why I asked that is a procedural reason. I would greatly appreciate, as the chair, that we make a finding on something. Either a motion to table, a motion to deny what you have now admitted is really a motion for attorney's fees, which you term as a motion for frivolousness, and we rule on that one way or another. But I don't want to just let this hanging out. I mean, I think we need to be a commission of finality, and we need to provide finality one way or another. My position is that the request for frivolousness, which is what you just said, is a request for attorney's fees, should be denied, but that's only one amongst 5. I do want us to make a call. Commissioner Cranfield, what do you think?
This is something that just sort of came to mind as you were just speaking. Is this really tantamount to you asking for, I understand that you requested a finding of frivolousness, but in essence, are you saying, well, I did make a motion for attorney's fees, and it's more in the nature of seeking nominal damages or attorney's fees in the amount of 0. I just want a finding showing that it was frivolous.
And if I may, Mr. Commissioner, it's kind of like the qualified immunity debate everyone's having right now about clearly established law versus the finding of constitution. I think it's in the commission's interest to make findings that expound on what frivolousness is so that there is a body of law. And I think if the attorneys, like the amount of the attorney's fees question is sequenced improperly, it frustrates that ability to expound on this in the commission's interest so that future litigants don't go astray.
I think the question then is on the motion. I think it's a motion for attorney's fees, and it would just be whether or not to grant the motion for attorney's fees. And so if someone was going to make a motion, if the commission is going to take it up, it's going to, well, if you've made the motion, what we've got to make a ruling on it, I think.
Well, but
No, I agree.
the motion was made. It died for lack of a second. I did make the motion for attorney's fees. It died for lack of a second.
Correct.
And so,
The alternative motion would be for someone to move that Representative McLaurin's motion for attorney's fees be denied.
that was also moved, and it died for lack of a second.
That was actually a different motion. His motion was for frivolousness, not on a motion for attorney's fees.
My understanding was the chair made a motion to deny, go ahead.
To deny the request for frivolousness. That was the exact motion.
Okay, and so that's the motion that also died for lack of a second.
That's right. So someone can file a renewed motion.
Mr. Chairman, I think a point that needs to be made is there doesn't have to be an explicit reason to deny, and that's why I think Commissioner Watts disagreed with your motion to deny. If there's a motion to deny, even if upon different legal theories, 3 motions to deny carries. So I think what Commissioner Watts disagreed with you and withdrew his motion was the underlying basis, but that's not necessary to deny the motion. I'd like to clarify.
Now you're the mediator. All right, so look, I had an issue with the sequencing of it, certainly. I agree with everything Secretary Motti said. If our interpretation now is that there was some motion for attorney's fees made by the respondent, then happy to take that up. I don't think there was. I don't think you can bury that in a response. But if that's the view of the commission, that's fine. I'm fine voting on that. I'm not fine voting on finding frivolous.
All right, Commissioner Crandall?
I'm gonna make a very simple motion. My motion is to deny Representative McLaurin's motion. However it be characterized.
Point of order and unreadiness. Mr. Chair, I don't think that's a proper motion because we don't know what motion we're voting on. So I'm going to object to the motion on unreadiness because I believe the commissioner's motion was to deny the representative's motion, whatever that is. And I don't think that's a proper motion to vote on.
Well, the way that the motion was characterized in the pleading was a motion for frivolousness. We're now talking today that it's also been characterized as a motion for attorney's fees. What my motion is whether it be characterized as a motion for attorney's fees or a motion for frivolous, my motion is that that be denied.
Commissioner Watts?
So,
You sound like a bunch of lawyers at a table
Yeah.
arguing over formality.
well, in an effort of finality, like you said, I mean, and we do have to deal with whatever the motion is. And there are oftentimes, not that this was one of them, but there are oftentimes motions that were, inartfully worded that they get denied for something such as that, in court, or put in, a pleading or a filing where they shouldn't necessarily be put. It is what it is. So I will second the motion that Commissioner Crankville just made.
Okay. You got a motion and a second, and I'll agree. I mean, all pro se litigants just put your motions, but judges still have to rule on a motion. And I think we should rule on this motion request or however it was termed. And it's also a new rule so that at the end of the day, Mr. McLaurin, you provide clarity to the process. So any other discussion? Okay, I will call the question. All in favor, say aye. Aye. All opposed? Opposed. All right, the motion carries 4-1 with Commissioner Barnum is the sole opposition. We appreciate Mr. Tyson and Mr. McLaurin, you showing up. It's important to the process. And both of your arguments are important to making sure that we operate the best way that we can. We appreciate that. So with that, I will make a motion. I guess at this point, I've peed myself just about, but we will go ahead and I guess take a lunch break because it's 12. So I'll make a motion to adjourn if I get a second.
Second.
Recess? That's it. Okay, well, make an
We're not going
did you really have to do that? Not again. Make an amendment. Commissioner Watts, amend the motion for a recess.
I amend the motion for a recess.
Okay, I'll second that amendment. Any discussion? Hearing none. All in favor say aye. Aye. All opposed. All right, carries. All right. So I will call the meeting back to order, and we are in, and Commissioner Thompson, can you hear us?
I can.
Okay, good. The first order of business, and relates to the advisory opinion for consideration. We've had a number of members of the public that more recently became aware of this, and they requested an opportunity to review it, and also after they review it, provide a public opinion. And based upon that, it's in my opinion that we table this to the next meeting to make sure that all the members of the public have adequate time to review it and provide an input. So to that end, I will move that I guess the question is, should we wait until that's considered to table it, or should we table it now? Okay, I'll make the motion then that we table the proposed advisory opinion 2020-03, use of campaign funds for rent/lodging expenses, if I could get a second.
Second.
Okay. Got a motion and a second. Any discussion? Hearing none, I'll call the question.
I'm sorry.
Go
I just
ahead.
want to make
Sure.
because it was Mr. Chalmers' question, I just want to make sure that he doesn't have it. He's on the line.
Mr. Chairman, this is Mr. Chalmers. I'm here. Can you hear me?
I can. Go ahead, Mr. Chalmers.
Good afternoon. I hope you're all doing well. I appreciate briefly the opportunity to talk about this, and I don't have any great objection to this being tabled. I think it is important to get the right answer. I would note, though, that the statute requires an answer within 60 days. And so if we're going to table it, I would request that it be tabled to the very next meeting, which I understand is going to happen in September. I also wanted to offer a couple of comments on the advisory opinion, but to save you all time, if you're going to table it to the next meeting, I'll go ahead and submit those in writing. I do think that the draft that was submitted reaches the wrong conclusion. I believe that the statute does allow for this, and I'll be happy to spell those out in the letter, but we'll get that to you very shortly now.
Okay. Thank you, Mr. Chalmers, and we would appreciate your letter. As you know, we want to get the right answer, and tabling it is making sure that we get the right answer and everyone's got an opportunity to voice that. So please do. So, all right, we got a motion, we've got a second, we've got your comment, Commissioner Cranville. Any other comments? All right, hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, the motion carries, and we will table that directly to the September meeting, Secretary Marty. All right, so next we got the preliminary hearings, and the first one up is in the matters. Go ahead, Secretary Marty.
Mr. Chairman, I would ask that a motion be made to amend the agenda to move the preliminary hearing involving Ms. Allison Feliciano, which is letter F, to the top. Ms. Feliciano is here present. None of the other PCs are presently here, and she does need to get to work. So I would ask that someone make a motion to move her up so we can get her heard now.
Sure, I'll make that motion.
Second.
Motion and second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right. Motion carries. And Ms. Feliciano, you'll be up next, and I will call that one up for consideration. Who on behalf of the commission will be presenting?
Ms. Browder.
Okay. So Ms. Browder, whenever you're ready.
Thank you.
We can hear you. Go ahead.
Well, I have to wait if Erwin could make it so that you all can see my screen.
Okay.
I think I can see you.
Well,
Oh, PowerPoint, okay.
what I'm trying to show you. But while we're waiting on that, I will, like for the commissioners to know that, the presentation that I'm going to present, was prepared before today with the exception of a note that I added. But Ms. Feliciano, I learned yesterday, has been in communication with someone from the education / compliance part of the organization. I think maybe, I won't go as far as to say to usurp this process, but potentially in an effort to address some of these issues. And I believe within the last 24 hours or so has filed a DOI by email and a Form RC to register a committee. And I believe also a PSES, but I have not had an opportunity to review that. I am going to go forward with my presentation as is with the allegations, as they have already been drafted, but I do want to let the commission know that, and I know that Ms. Feliciano will be able to, address the commission if the commission sees fit once I am finished presenting my portion.
Okay.
Erwin, can we see her? Yeah, she can do the PowerPoint. Janine, Erwin says you can flip the screen, however you do that. Share it. There we go.
So are you all able to see my screen?
Yeah. Yes.
Okay, so I also have, I've noted the page numbers in the e-binder that corresponds with the slides that I have. And so I can also provide those. The first slide from Ms. Feliciano's PowerPoint starts on page 357 of the PDF for the e-binder. And so we are here on the matter of Ms. Allison Feliciano, case number 2018-0126. As far as I understand, Ms. Feliciano will be proceeding pro se. And just as an overview, Ms. Feliciano in 2018 was an unsuccessful candidate for State House Representative for District 19. She has again qualified for a election to the General Assembly for this same office. Ms. Feliciano, prior to the last 24 hours, had neglected to file any of the required disclosure documents and had not responded, to my knowledge, to any of the mailings that we had sent related to there being an active complaint against Ms. Feliciano. And this slide will be the only slide that's different from what you had in your e-binder, because I added this note at the bottom. Just some background information and important dates on Ms. Feliciano's matter. She qualified in 2018 on March 8th, and she qualified this year on March 6th. And her qualifying, or wanting to qualify this year, actually is what led to her initial contact with the commission, which was through a department that handles fees with our office. Procedurally, a third party filed a complaint on November 7, 2018, alleging that Ms. Feliciano had violated the Campaign Finance Act. The staff, prior to my tenure and since I've been here, had attempted to serve Ms. Feliciano on 3 occasions, 3 different addresses, one including out of state. This third address that you see, or you may not be able to read, is in Dallas, Georgia, and that address actually came from Ms. Feliciano. However, the attempt at service via U.S. certified mail was unsuccessful because it was not retrieved. On April 8th, I actually sent a follow-up email to Ms. Feliciano to let her know that the attempt at service through the U.S. Postal Service was unsuccessful, but did not get a response from Ms. Feliciano. And so on June 9th, we sent an overnight UPS delivery service attempt to Ms. Feliciano, which was left by UPS at her door, and it contained a notice of complaint, notice of additional allegations, and a notice of hearing for this date. And that actually would have been at least the second successful time that she had received at least the notice of complaint and notice of additional allegations, because I was able to email those things to her in March after she reached out to the members of the staff that handle fees related to her wanting to qualify again for 2020. Subsequent to the latest mailings, staff also issued some subpoenas to PayPal and ActBlue. Not present on here are also subpoenas that have been sent to Bank of America and Square for Cash App. And we have not received a written response to the complaint, but of course, Ms. Feliciano is present. So the allegations that I am addressing today are Ms. Feliciano's failure to file a declaration of intentions to accept campaign contributions, her failure to file CCDRs for March, June, September, October, December of 2018, January and June 2019, and January of 2020. And the January of 2020 was her qualifying for this year and would have just been a non-election year CCDR. And Ms. Feliciano had also failed to file a PFDS for 2018 or 2020. And so under the Act, this is 21-5-30, a candidate for a state office, which Ms. Feliciano has qualified for, is required to file a PFDS within 15 days of qualifying. And this is just an image of what that form looks like. It's actually a pretty short form. And this form is normally required, a hard copy of this form is supposed to be filed with our commission, either in person, hand delivered, or by mail. But I believe the staff that Ms. Feliciano has been interacting with have been willing to accept her form by email. And so this is just a screenshot now showing that Ms. Feliciano had not filed any DOIs with our office. And then we'll move on to, just so that you can have some images of Ms. Feliciano's solicitation for campaign funds, even though she had not filed any of the required documents. So this is an image of Ms. Feliciano's Facebook page. And as you can see from this About section, this page has existed since 2015. So this page has been in existence over 5.5 years. And commissioners, if at any point you need me to let you know what page my slide is on in the binder, please just stop me and let me know. And so now you can see a post from February 26, 2018. And in this post, I have circled or highlighted with a red oval showing an AdBlue link, which of course is a platform that allows for people to contribute to campaigns. And here you have what is a screenshot of an Instagram page, which although the Instagram handle does not list Ms. Feliciano's campaign name or even her full name, what you do have is Ms. Feliciano's image, which appears to be a professionally taken headshot, as well as this oval highlight. I hope you can see it, but this is what would be how someone could find a person on Cash App. It's a $ or a dollar symbol, and then Ms. Feliciano's name, Allison Feliciano. And I've also gone ahead and highlighted the date that I was on my computer when I pulled this up, which was March 5th, 2020. And this shows that this post was 3 days before that. And here we have a screenshot of a PayPal link that I also pulled up earlier this year and was still active. And so moving on to what I believe or staff believes are expenditures or contributions. Here you have a placard or a card bearing the same headshot image that was shared in that Instagram screenshot. And this is clearly material campaign for Ms. Feliciano for the State House District race. And this picture is from a social media post from 2018, which is shown up top. And then this is the back of that same card. And here you have an image of Ms. Feliciano with some people, and there's a guy standing behind Ms. Feliciano with a sign that appears to read in support of her campaign. What you can't make out all the words across the bottom, but what is legible is the word Georgia and the beginnings of what looks to be representative. And if you look over the shoulder of the gentleman wearing the white hat, you see what looks to be possibly the corner of additional signs similar to the one that Ms. Feliciano is pictured here with. And this post is also from 2018. And then this, another image from 2018 from social media showing Ms. Feliciano and a person holding that campaign literature. And then moving on to campaign contribution disclosure reports. And so the statute 21-5-34 sets out the required filing with due dates for the CCDRs that a candidate should file. And so for Ms. Feliciano, she would or was subject to these requirements. And in the non-election year, I've underlined that January 31st and June 30th CCRs are to be filed. And during an election year, which would have been 2018 and the current year, Ms. Feliciano would have needed to file January 31st, April 30th, June 30th, September 30th, October 25th, and December 31st, depending on when she had filed a VOI, if she had filed a VOI. And so here, you can see a screenshot that of course was prior to today showing that Ms. Feliciano had filed no campaign contribution disclosure reports. And these are two charts showing like a pictorial just to give a display of what was required and what was not received. And so of these CCDRs that were due in 2018 and 2019 that are pictured, the only one that would not have been required is the January 31st CCDR for 2018 because that was before Ms. Feliciano qualified and potentially before she accepted campaign contributions. convictions, although we don't know that yet. And then this is the 2020, where this image is not saying that Ms. Feliciano was not required to file the CCDRs between April and present day. It's just that there was no notice given for this hearing or for this presentation to Ms. Feliciano about these documents. Going to the personal financial disclosure statement, 21-5-50 is what requires Ms. Feliciano or any other candidate seeking a state office to file a PFDS within 15 days of qualifying for that election. And here you see a chart showing that Ms. Feliciano should have filed a PFDS in 2018 by March 23rd, 2018, and did not. And this year, Ms. Feliciano should have filed a PFDS by March 21st, and did not. But my understanding is that within the last 12 to 24 hours, Ms. Feliciano has filed a PFDS, but I have not seen that. And so here is just a screenshot from showing that Ms. Feliciano had not filed any personal financial disclosure reports. I would note that the other two positions that Ms. Feliciano sought were local positions. They're not really relevant here, but they wouldn't require a PFDS anyway. And then in summary, Ms. Feliciano has run at the same seat. This is her second time. Prior to the last 24 hours, Ms. Feliciano had not filed a DOI. Ms. Feliciano had not filed any CCDRs. Ms. Feliciano had not filed any PFDSs. However, Ms. Feliciano had maintained a social media presence that she used to campaign and solicit campaign contributions. And so for that reason, the staff is asking that the commission find that there are reasonable grounds to believe that the Campaign Finance Act has been violated.
Okay, so has she filed anything?
So I received emails, I was added to emails yesterday, and she submitted by email a declaration of intention to accept campaign contributions and a form registering a committee. Normally those things are not allowed on email, but I don't know, I don't know if there has been some change because of the current state of the world, essentially. And then also the PFDS, I've not had access to that, but I have seen the email where a member of staff told her they saw that she filed a PFDS between maybe now and last night. I don't know when exactly, but I haven't seen those things.
All right, Ms. Feliciano, whenever you're ready to get.
Want me to go to them?
That would be great.
Great.
That way everyone can hear you because there's a mic over here.
Great, thank you. It's okay that I keep this off while I speak? Okay. Thank you so much. Good afternoon, Chairman, and to the commission. And I wish I could say that none of that was false, but it's true, but I'm here to explain why. In 2018, I was asked to run for the office to represent District 19. First time ever attempting that type of office. I had the beginnings of some health issues, but I didn't know at that time how severe. Shortly after I did qualify and I did bring proof, I spent more time at Wellstar and Piedmont in 2018 than I really did expect. I actually was told I had a 50% chance of survival. Thank God I'm here today. My daughter also was born with sickle cell, and when she was pretty okay as a child, when she hit puberty and when my late husband passed away, it tended to make that worse. And so she's been in and out of the hospital for the last 2 years. I had a campaign manager in 2018. I really did believe, because I did sign a lot of stuff. I hate to call it stuff, forms, but to me stuff. So I thought that the DOI was filed then. I had no idea until, and when I did receive the first, and the address that I saw on the first mailing that I did get, which was my old address, I thought this is probably a mistake, and I did not understand what I was being sent, and my name was spelled wrong, and so And then to see my old address from New York that I have not lived in since 2008 is kind of surprising. So this year, I did not expect to run again. Well, let's go back to 2018. When I was okay enough to go out to campaign, my campaign manager had purchased the cards and we had about maybe 10 signs in all. And the days that I did have strength to go do that, those are the pictures that you see. I thought when I did not win that was the end of it. And I just went back to my life. 2019 and fully recovering, 2020 comes and they called me at the very last minute. I think I had 4 days to prepare, maybe 5, to run again. And so in choosing that, I said yes. I take full responsibility in everything that was said. If I was able to handle paperwork for the Veterans Administration on behalf of myself and my late husband, I could figure out. They weren't easy, but I could figure out documentation. When I qualified, that was right before COVID, and it just seems the stress that COVID put on my daughter. With sickle cell, you never know what's going to happen, but more stress. She's been in and out of the hospital for the last 4 months, and I have also lost 4 family members in that time. So I've been less than focused. And I do not have a campaign manager this time, but in understanding, I don't even have access to the Act Blue, so I did attempt to figure out how to even get to that. So I am more than willing to take the responsibility to catch up on the paperwork. And I did get, in the midnight hour, 2 people that did say that they would help me now. Because I did not fully understand everything that I got in the mail. I thought I just had to come here today. I did not know that I had to respond. I do have Legal Shield, and I did send it to them, and they told me that it wasn't a lawsuit. So I did not think I had to respond in writing, so I apologize for that. And I certainly take all responsibility. I do not want to be out of compliance on anything. I will say paperwork is not my forte, but I will stick my nose to the grind to get it done. And so that's my explanation. To no disrespect of the office or to the committee or the commission.
All right, thank you very much for showing up. Does the commissioners have any questions or comments? Commissioner Barnum?
Yes, and I guess my question is for our staff. I noticed Ms. Browder in the proposed resolution, there's a recommendation that it be referred to the Georgia Department of Law for further administrative proceedings. Walk me through, has there been any effort to reach some type of negotiated resolution with Ms. Feliciano? Is that possible given where we are in the posture of the case? We typically see these things come before us and there's okay, get your disclosures on file, pay a fine, and we're going to expect that, you remain in compliance. Has there been any consideration of something short of referring it to the AG's office?
No, and my request remains that the commission find reasonable grounds and that it is referred to the AG's office so that it can proceed to OSA. There has been no conversation about some type of alternative resolution because Ms. Feliciano has not entered with me. I learned of Ms. Feliciano contacting the office staff related to a fee that was showing online because she wanted to qualify for 2020. That person in turn realized that there was an open complaint against Ms. Feliciano and let me know. And that is how I came to have email contact with Ms. Feliciano in March. That contact included me emailing Ms. Feliciano the complaint, the additional allegations, and a hearing notice for June. Ms. Feliciano responded that essentially she wasn't aware and she would take care of it immediately. That was in March of 2018. My request stands as presented because Ms. Feliciano has had since March to make some type of effort towards resolution, but Ms. Feliciano has not done that. Ms. Feliciano did reach out to a member of the staff that was not that person that worked on the fees, but is someone that is over education in an effort to, I'm not sure if it was supposed to be related to this or not, because she did not mention to the person that she had an open complaint, and that person was unaware until yesterday when Ms. Feliciano sent an email to the general commission email address. And that email address, whoever received the email in turn emailed me and 2 other members of the staff. And that is how they learned that Ms. Feliciano had an open complaint. And so I think if there's going to be any, alternative way to resolve this, it should be done during the 30 days that a respondent has post the commission finding that there are reasonable grounds to find that the Campaign Finance Act has been violated. That way, if communication again breaks down and we go for an extended period without receiving anything, we don't have to jump through the circles again of trying to locate Ms. Feliciano and then go through this proceeding an additional time.
Well, I mean, I can appreciate that, Ms. Browder, jumping through circles is kind of what we do.
Can I just,
Well, Ms. Feliciano, I want you to, I'd like you to speak to Ms. Browder's, position as to why they should be referred directly to the AG's office and not remain with the commission. And in your response, I think it is important for me to hear why you haven't taken advantage of opportunities presented to work with the commission, with our staff. I have no doubt that Ms. Browder would have made herself available to work with you prior to today, because she's asking for this to be referred to the AG's office and not remain here. I don't think that she would do that if she thought that you were being cooperative and responsive. Can you speak to that, please?
absolutely, and I could certainly, this is definitely an apology to Attorney Browder because it was in no disrespect at all. And I did contact, I've been interacting with Holly because I was told by someone I had a FIN number or something and I could not find it. And that was my first initial email to them. And that's how I got the email thread with Holly of I cannot get on to, I know I was attempting to file something that someone told me at the last minute I had to file. And then in and out of the hospital with my daughter and our personal losses. And so, and I also did not understand, I really thought I had to just come here today. And believe me, I've been through, with my ex-husband, family court. I know how to respond properly and appropriately and respectfully to complaints. But when I did send this to my Legal Shield membership attorney, they told me this is not a court case, just show up that day. So that's why I'm here. And I did print out my medical history to prove that, I was. So I would have certainly, if I knew that I could have handled this prior, and I'm just gonna tell you, my daughter is my priority. Not that serving the people is not, but she's my only daughter. And if you know of anyone that has a child that was born with a disease and it's a blood disorder, I spend more time in hospitals than I care to. So I would certainly, I am asking for grace and mercy that I would be able to catch up on all of the reports that have not been. I know for a fact that we probably didn't, if we were lucky to raise $800 in 2018, because I didn't have the strength to fundraise. But I'll do whatever I can to get everything that I can up to date to make myself compliant before the committee, and I'm asking that Attorney Browder would consider.
Commissioner Cranfield?
Ma'am, I want you to sort of understand where we are procedurally and what posture we're in. We're here now, as in a preliminary hearing to determine whether we would find reasonable cause to believe that the Campaign Finance Act has been violated. Commission staff will have really 30 days. If we were to find reasonable cause today, okay, commission staff would have 30 days to sit down with you and potentially negotiate out a resolution of all of these issues, even if we do find reasonable cause today. And if we do find reasonable cause today, I would urge you to, as soon as possible, sit down with commission staff and try to come to a resolution of these issues. One of the things you can do, and I'm not giving you legal advice, I'm just advising you that from what I've heard today with some of the issues involved and some of the questions involved, and then commission staff can educate you more on this, there can be something that's called a hardship waiver as to any fines that may be imposed as a result of the violations that have occurred. But that's where we are here procedurally in the posture that we're in today. So that's the question. I don't want you to think that if we in fact find reasonable cause to believe that the act was violated, that it's over and therefore it's going to immediately go to the Attorney General. You will have this 30-day period to work with staff, and I would urge you to do that if that's what happens today.
All right, commissioners have any other comments or questions? All right, well, I'll make the motion to find that reasonable grounds exist that the Campaign Finance Act was violated, and I'll second what Vice Chairman Cranfield said, which is I try to speak with the commission staff and see if you guys could work out, and at the end of the day, a consent order at the end of the day, that would come back before us, which would be approved or considered approved or denied by us. But the question before us is limited to whether there's reasonable grounds to believe that the act was violated, and I think that there's agreement between you and the commission staff there was. So I will make that motion.
I'll second that.
All right, you got the motion, and we got a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, the motion carries 5-0, and thank you very much for coming today.
Okay, so I'm sorry for just lack of knowledge, what,
Ms. Browder,
Ms. Browder will be in touch with you, and there are gonna be some things we need to look at, and we'll sit down with you and talk about that, and then we can talk about how to resolve the case.
okay.
So, maybe get us till next week, but we'll get in touch with you.
Ms. Feliciano?
Please go, lawyer. Okay, for your benefit, it's not legal shield or legal Zoom or, please go, lawyer.
Absolutely. Thank you so much.
All right, thank you, Ms. Feliciano. Okay, so next, we need where's my parliamentarian? Do I have to amend to just call can I just call it? Or do we need to amend? If we need to amend,
Do we need to amend to reorder the cases?
I can just call the next one, okay. So what we'll do is we've got someone here, the complainant is here in the matter of Erica Thomas. So to be courteous to their schedule, we will call that one next. And it looks like Ms. Browder, you're appearing on behalf of the staff, so if you could present that one, and then I think Mr. Shepherd is here, who is the complainant, and then he'll have an opportunity to comment as well.
Okay.
So Ms. Browder, whenever you're ready. I'm trying to find it. Ms. Browder, do you know what page it is in our binder? It's 3 down on the preliminary hearing.
Sure, can you hear me?
We can.
Her case starts at page 308, and then the slides begin at 312. I am just trying to set my computer back up because I had stopped sharing my screen because I didn't realize I would go again.
That's okay. We're patient. We're ready when you are.
Commissioners, in your e-binder, if you will actually click on your case name on that agenda, it will take you straight there.
I can't get that to come down for some reason. Yeah, that's okay. I've got it now.
Okay, so we are here on the matter of Erica R. Thomas, case number 2019-0031. I have Ms. Thomas down as pro se, but as you said, someone is there here on her behalf.
Is someone here for her?
No, no.
Okay.
Oh, I thought you said someone was. Oh, okay.
No, that's okay. I just wanted to make sure about that. I forgot to ask that, Ms. Browder. That was my fault. Go ahead.
Okay.
Who's the complainant?
The complainant, who is the complainant?
Mr. Shepherd.
Mr. Shepherd is here for the complaint.
So this presentation will cover the time period from June 2018 through April 2020. The period prior to June 2018 is actually covered in a commission preliminary hearing in December of 2019. And so these slides are actually a little bit out of order, but I didn't want to change them because the commissioners already had the binder slides in them. And so the overview slide is further down. But procedurally, Mr. Shepherd filed a complaint on August 21st, 2019, and we attempted service by certified mail at Representative Thomas's P.O. box, and that was unsuccessful. And so in May of 2020, on the 26th, the commission was able to successfully serve Ms. Thomas via her legislative office address. Ms. Thomas has not filed a written response. And by way of overview, Ms. Thomas is the state representative for District 39 after having been elected in 2014. Ms. Thomas has only filed a portion of the disclosures that are required, or the campaign contribution disclosures that have been required. Ms. Thomas has filed none of the personal financial disclosure statements, and Ms. Thomas has not disclosed contributions that she has received that have been disclosed to the commission as expenditures by other parties. And Ms. Thomas has also failed to disclose expenditures that she or her campaign have made. So back on February 3rd, 2014, that's when Ms. Thomas initially filed a declaration of intention to accept campaign contributions. She also filed a form to register a committee. Ms. Thomas had a personal financial disclosure statement covering the year of 2019 that was due in that was covering the year of 2018 that was due by July of 2019. On March 2nd of this year, Ms. Thomas qualified to stand for election as the incumbent in the primary election. And with that qualifying, Ms. Thomas had another personal financial disclosure statement that was due on or before March 17th, 2020. The alleged violations are that Ms. Thomas has failed to file campaign contribution disclosure reports for June, September, October, and December of 2018, that she failed to disclose campaign contributions greater than $100, that she failed to disclose corporate, labor union, or other affiliation of political action committee or independent committee making contributions of more than $100, that she failed to disclose expenditures that exceeded $100, and that she failed to file a personal financial disclosure statement for the calendar years 2018 and 2019, which would have been due last year and this year. So 21-5-34 is the statute that sets out when these campaign contribution disclosure reports are due for non-election years, January 31st and June 30th, and for election years, January 31st, April 30th, June 30th, September 30th, October 25th, and December 31st. And that same statute, but in a subsection, also requires that candidates and public officers, those receiving funds, disclose contributions that exceed $100. It also explains that they have to provide the names of individuals that make those contributions and their employers, and they also have to disclose if those contributions are coming from any corporation or labor union or any other political action committee or independent committee. And so here, a chart showing the required CCDRs that should have been filed by Ms. Thomas, and also shows the CCDRs that have been filed. And so for 2018, Ms. Thomas did not file any of the CCDRs that are listed. In 2019 and 2020, Ms. Thomas did file and timely filed CCDRs for January 30th, January 31st, and June 30th, 2019, and also January 31st and April 30th for 2020. And so this image is, you may not be able to make out the numbers, but this is a page from Ms. Thomas's April 30th, 2020 CCDR. And if you can't make out the image, there are no numbers disclosed. Essentially, the form just shows all zeros, meaning that there were no contributions, there were no expenditures, there were no loans to the campaign. And the same for the January 31st, 2020 CCDR, also all zeros. And the same for June 30th, 2019 CCDR, all zeros. And the January 31st, 2019 CCDR as the others, all zeros. And so as far as the undisclosed contributions, Ms. Thomas received, from what we can tell, 27 contributions that were reported as expenditures by political action committees. And these 27 contributions came from 25 contributors. And the total amount of these contributions was over $16,000. There were no contributions reported by Ms. Thomas. There were no contributors reported by Ms. Thomas. Hence all the zeros on the CCDRs for the images that I showed in the prior slides. And so this is just a screenshot of the query that was used to discover the expenditures of other filers that listed Ms. Thomas or her campaign as the recipient. And in the center, it shows date from, and the query started with June 1st, 2018. And so this is a screenshot of what the page looks like when you run that query. And I have put a yellow oval around the click here so that the data can be exported to a Microsoft Excel worksheet. And so I imagine this may be likely illegible, really, if you're looking at it on the computer screen. I'm not sure what it looks like in the binder, but maybe you can zoom. But these are rows of expenditures by PACs that list Ms. Thomas as the recipient. And if you look where the red rectangle is, those are the amounts of the different contributions. And so at the bottom, I've noted that there was one contribution that was $100 on January 3rd, 2019. And so if Ms. Thomas had disclosed these contributions that she received, that $100 contribution would not have been required. And that one is row 12. And so now looking at undisclosed, or what staff believe are undisclosed expenditures, these are images from the complaint that was filed, the third-party complaint filed against Ms. Thomas, and it's a copy of what appears to be a flyer for a fundraiser for Ms. Thomas and another member of the General Assembly. And then here is another version of that that I was able to find on social media. And now this is the Secretary of State's website that shows, the candidates that qualified for an election. And near the bottom, you'll see Ms. Thomas is listed as the third candidate. And I have used a red oval to highlight Ms. Thomas's website, which is what staff is putting forth as an undisclosed expenditure. And here is a screenshot from Ms. Thomas's website. you can see the website in the bar at the top, and then of course Ms. Thomas is pictured on this home page inside the Gold Dome. And at the bottom of that page, this is a screenshot at the bottom, and you'll see I have two ovals. One oval reads, paid for by Erica Thomas for Georgia State Representative, District 39. And then the smaller oval reads, copyright 2020, elect Erica Thomas. Moving on to the personal financial disclosure statements, 21-5-50 is a statute that requires that a candidate for a state office file a PFDS within 15 days of qualifying. Now, had Ms. Thomas not qualified for the election, then her PFDS would not have been due until July 1st. But because she did qualify, it was due within 15 days of her qualifying. And so now on this slide, we just have a chart showing the two PFDSs that Ms. Thomas should have filed, one in 2019 as a public officer, and then one in 2020 as a candidate. And the one for 2020 was due by March 17th, and neither of these have been filed. In summary, Ms. Thomas has ran for re-election in 2018 and 2020. Ms. Thomas has filed half of the campaign contribution disclosure reports that are required, and Ms. Thomas has not reported any of the contributions that were received from political action committees. Ms. Thomas has not reported any of the expenditures, and Ms. Thomas has not filed any of the required personal financial disclosure statements. And so, for those reasons, the staff asks that the commission find that there are reasonable grounds to believe that a campaign finance act has been violated.
Okay, thank you, Ms. Browder. And the complainant, Mr. Shepard, if you have any further comment, please go ahead. And can you hear us, Mr. Shepard?
His mic is not on.
You may be muted, Mr. Shepard. We can't see you either. Let's see if we can, maybe Ms. Browder, if you stop sharing your screen, see if that'll help. There we go. Okay. Yeah, we still can't hear you, Mr. Shepard.
His mic is off.
I'm hearing that your mic is off.
The one up here, or? Yeah, even the one on the phone, it's off right now. I think he's calling in on the phone.
Are you?
It's off. I put it on mute. There you go.
Sorry, I forgot the star step. I'll just add that I really have nothing to add to the staff report. It was an excellent report and covered more than my complaints alleged. So thank you all for hearing it, and look forward to it going forward.
Okay. Thank you, Mr. Shepard. Ms. Browder, did Ms. Thomas, was she served with notice of that this preliminary hearing would be going forward today?
Yes, I followed up with our deputy secretary, and he assured me that notice for the hearing had been served.
Okay. And did she intend to attend today, or what was her comment, or did you hear any comments?
I received no response from Representative Thomas.
Okay. Yeah, Secretary Monty, do you have any comment to that?
Not specific necessarily to this case, but just as a point of interest. What we typically do when we have a case that involves a state elected official is we will send certified notice to their home address. We'll also send it to their legislative office, sort of a double service to make sure that their staff is getting it forwarded along. So I just wanted to make that point.
Okay. All right. Do the commissioners have any questions, comments? None? Okay. Well, I will, in light of the staff's report, I'll make the motion that reasonable grounds exist that the Campaign Finance Act was violated in the matter of Erica Thomas. If I could get a second.
Second.
Okay, we've got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, motion carries 4-0 with Commissioner Watts absent. So next we've got Jeff, in the matter of Jeff Holcomb, and I believe, Mr. Cusack, that's yours, so
That's
take
correct.
it away.
Mr. Chair, this is actually going to be a consent order.
Okay.
Mr. Holcomb consented to this late, I believe, either early this week or late last week after the agenda had been published. But this was a complaint that was filed on May 22nd, 2020. Mr. Holcomb did not file a PFDS, and there was kind of how this complaint began was there was also a missing CCDR filing. He has run for office before and had misplaced his PIN, and so filed that CCDR under his old PIN and didn't realize he needed to file it under the 2020 election because he ran for office in 2018. So that missing report was actually in his 2018 run for office. So he complied with sort of the letter of the law, or the spirit of the law, but not the letter of the law. So he's just getting dinged for his lack of a PFDS. Because he disclosed everything in that CCDR, it was just filed under the wrong year, if that makes sense. So he agreed to pay $125 late fee for not filing his PFDS, but everything on that CCDR that he filed in the wrong place was for the 2020 race. So that's why this complaint was initially for not filing that CCDR. He did file it just in the wrong place, and then he rectified that and got it over to the right account.
Okay. All right. Commissioners have any questions? Commissioner Thompson, are you still with us?
I am still with you.
I know you have a question on this one.
I did not.
Well, he seems to have signed off on it, and it seems to be finalized, so I have no issue with it. I'll make the motion that we adopt the proposed consent order in the matter of Jeff Holcomb. Okay, got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. All opposed? All right, ayes have it, 4-0. And then next up is the matter of, I don't want to say that incorrectly, Ms. Browder, but the Stevens matter.
Stevens,
Yeah, say the first name again.
Key Antoine.
Key Antoine Stevens, okay.
Stevens. Mm-hmm.
Go ahead, whenever you're ready.
The matter of Key Antoine Stevens, case number 20-0007-C, comes before the commission. Mr. Stevens, I don't believe is present, would be proceeding pro se. As an overview, Mr. Stevens currently serves as a member of the Clark County Board of Education following an appointment on January 16, 2020. Mr. Stevens was a 2018 candidate for the Athens-Clark County mayoral race, but did not qualify for election. Mr. Stevens solicited contributions and only filed 2 campaign contribution disclosure reports. Mr. Stevens later contradicted the information that he disclosed in his CCDRs. So on February 10, 2020, Mr. William Perry filed a third-party complaint alleging that Mr. Stevens had violated the Campaign Finance Act. Mr. Stevens was served with notice of the complaint on March 11, 2020. And on June 11, 2020, Mr. Stevens was served with notice of additional allegations. Mr. Stevens did not submit a written response to the complaint or to the notice of additional allegations. I'll also add for the commissioners that we first attempted service at Mr. Stevens' residence, and he did not, no one accepted that service through the United States Postal Service certified mail, and so we served Mr. Stevens through the Board of Education. So the third-party complaint alleged that Mr. Stevens had listed on his CCDR a net balance of $88,695.33, and that he had failed to file any subsequent report and therefore did not disclose how those funds were dispersed. Mr. Stevens also listed $55,514 as his total contributions of contributions that would not have needed to be itemized because they were $100 or less. And the complainant found that to be highly unusual for really any campaign, but especially for a municipal level campaign. The additional allegations that we're bringing before the commission are that Mr. Stevens failed to file his campaign contribution disclosure report for June 30th, 2018, and that he also failed to file non-election year campaign contribution disclosure reports for January 31st, 2019 and December 31st, 2019. So 21-5-34, as we heard, sets out the requirements for when campaign contribution reports should be filed. And under subsection C, Mr. Stevens, had he qualified, would have had some requirements that are a little bit different because he actually did not qualify. And so 21-5-34 requires that contributions that exceed $100 be disclosed, and that specific information about the contributors be provided, and also that any expenditures exceeding $100 be disclosed as well.
So he was raising money, but he didn't qualify? Did he not qualify because he didn't fill out the documentation, or why did he not qualify?
Well, I'm not sure why Mr. Stevens chose to not qualify.
Oh, okay.
It may actually have been covered in one of his social media posts, but he definitely didn't qualify. He stopped campaigning for the race. But yes, he started campaigning and
before the qualification period.
In 2017. And then in March of 2018, chose not to qualify.
Okay.
The statute actually provides for different filing dates when a person doesn't qualify. So they're not subject to the same dates that were discussed in prior cases.
Okay.
So here's actually, I said statute, but here's Commission Rule 189-3-.01, subsection 4A on campaign contribution disclosure reports. I'll read just in case there's someone here that can't see it. Read campaign contribution disclosure reports by candidates who file a declaration of intention to accept campaign contributions, but do not qualify to run for office. If a person files a DOI but does not qualify to run for office, the following campaign contribution disclosure reports are required. Persons who would have been in a primary election must file the June 30th campaign contribution disclosure report and the July 31st CCDR immediately following the election referred to in the DOIs. Any person who has excess contributions from the campaign must file a December 31st supplemental campaign contribution disclosure report each year thereafter until the contributions are expended. And so on this next slide, here is an image of Mr. Stevens' DOI from May of 2017. And then here is a chart of the required CCDRs for Mr. Stevens. There would have been one file required in June of 2017, which was a non-election year. And then in 2018, which was the election year, there of course was the January 31st requirement, and that was then pre-qualifying. And that is the CCDR that is the subject of the complaint. And then on June 30th, this CCDR for 2018 was required under the rule that specifically addresses candidates that do not qualify. And then 2019, these two required filings for January and December also because of the rule.
Okay.
So here are images of Mr. Stevens' June 30th, 2017 CCDR. And so on the left side, it's a screenshot, like a full image of page 2 of the CCDR. Excuse me. And then on the right side, the rows 1 through 6 are highlighted, which includes total contributions to date, total contributions reported for that period, loans, which he does have something listed. And I believe that's all where and itemized contributions. And so here, his contributions to date were a little over $9,000. And if we move to the January 31st, 2018 CCDR, I sort of broke down the rows so that you would have hopefully easier access to the information. But if you look at row 6, the total contributions has jumped to $102,000, and this is where on row 4, he reports having more than $55,000 in contributions of $100 or less. He also has itemized expenditures for $13,000, which is in that second block on the right. And then at the bottom, that last block, row 15 on the right side, it shows a net balance on hand of $88,000, a little more than $88,000. So here's a screenshot from the Secretary of State's website for the candidates that did qualify. And as you can see, there are 3 individuals who qualified for the election, but Mr. Stevens is not one of those names. And so next we'll look at his solicitation and the access. So here's a screenshot of a social media post from Mr. Stevens, and it includes a link for raisethemoney.com and a specific request for people to donate. And then this is what one would see if they went to that link on raisethemoney.com. And at the top it clearly states Antoine Stevens for Mayor of Athens. And then the rest of the form one could fill out to potentially donate funds to Mr. Stevens. And so finally, here is a social media post that I'll read at least through the part that I think speaks specific to this case. But if the commissioners want me to read the entire post, I could do that as well. It reads, statement from School Board Representative Antoine Stevens. I want to start off by saying thank you to those who have sent your blessings, prayers, and advice as of late, as I have battled with my health behind the scenes and media. As promised, I am doing an in-depth statement on issues not relating to the Clark County School District. I've come to my community today out of humility. It is time to set the record straight directly from me. I take full responsibility and apologize to my community for my many mistakes made as a young person that entered politics without mentors. As many of you have already known, after my statement in 2018, numbers from my run for mayor of Athens were fabricated as a publicity stunt to raise awareness to the issues that I cared about in my local community and to fight for election fairness in a race where lower tier candidates were being unfairly excluded. $0 was raised in that race and expenditures were covered by me. I said then and I say now it was wrong, and I accept the fines that come along with that. And so this is what is stated on the left side. I will add that today we have had no contact with Mr. Stevens. I did try to search for whatever statement was made in 2018 that was referring to, but I could not find that. And so in summary, Mr. Stevens campaigned for mayor in 2018 and 2017 for mayor of Athens Clark County. Mr. Stevens did not qualify for the mayoral election, and he has failed to file 3 CCDRs he required to file. And he has failed to disclose any contributions or expenditures since his January 2018 CCDR. And so for those reasons, the staff asks that the commission find that there are reasonable grounds to believe that the act has been violated.
Okay. And was Mr. Stevens served?
Yes,
He was, and you said you could not connect with him, speak with him?
no, so he did not accept the certified mail through his residence, and so we served him through his Board of Education office. We sent the original complaint in March, I believe, and then we sent a notice of additional allegations a couple of months later.
Okay.
All through
Did he receive notice that this preliminary hearing was going to be today?
Yes.
He did? Okay. Commissioners have any questions? All right. Well, I will make the motion that reasonable grounds exist that the Campaign Finance Act was violated in the matter of Key Anthon Stevens, if I can get a second.
Second.
So we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. All opposed?
Aye.
All right, the motion carries 4-0 with Commissioner Watts absent. All right, and Osborne Nesbitt Senior, can we group these into one? Yeah. Ms. Browder, can we group the two Osborne Nesbitt Senior matter into one?
So actually, there won't be a hearing on this one, and I don't know if at some point Mr. Lane will want to speak, but I will preliminarily say that Mr. Nesbitt's case is not going forward because Mr. Thomas submitted a leave of absence. His leave of absence is dated February 2020. I received a copy from Mr. Thomas by email, I believe, after this hearing is set. But I would also let the commissioners know that this actually came before the commission in December, and we had a full preliminary hearing where Mr. Watts had questions about whether or not expenditures could be attributed to Mr. Osborne, and ultimately the commission did find that there were reasonable grounds. However, once I returned to the office, I was informed that Mr. Thomas had submitted a conflict letter. And I later learned that the conflict letter was from November. And so it shouldn't have proceeded in December.
Okay. So those two will just be continued.
Right.
All right. Got it. Okay, next motion to dismiss is Mr. Lane. We got in the matter of Ms. Goodson. Mr. or Ms. Goodson, if you can go ahead and tee that one up.
Thank you, Mr. Chairman. And as far as Mr. Thomas, just so the commission is aware, in addition to the Nesbitt matters, there's several other cases that we've been trying to get Mr. Thomas on. So going forward, we're scheduling all of his cases for each commission meeting that's coming up. And then when he files his conflict letters, as he is wont to do, we will be filing objections under Uniform Superior Court rule, asking for superior courts and lower level courts to grant permission from the Imperial Royale, as we promise his cases will move quickly. So just as an FYI.
Okay, yeah, we would appreciate that if we could move those cases.
Absolutely. As far as the matter of Condalowery Goodson, for Ms. Goodson's case, this is an old 2016 case that came before the commission. The commission found reasonable grounds to believe that a violation of the Campaign Finance Act had occurred. To be specific, the commission found reasonable grounds to believe that Ms. Goodson had failed to file one personal financial disclosure statement and one campaign contribution disclosure report. Further attempts at negotiations failed. The matters were referred to the Attorney General's office for further prosecution. Mr. Fuller drafted statements of matters asserted, and from that point, the commission needs to know that since the commission uses the Office of State Administrative Hearings as your hearing officer for all final hearings, the Office of State Administrative Hearings internal rules require that the statement of matters asserted be served by certified mail. So we run into the problem
tech evaluations, negotiations, and then ultimately award. Initially, we were in a pretty good place back in March, getting ready to move forward in selecting a vendor, and then of course COVID happens, and it's delayed this process several months. The tentative plan, and it is the plan, is that the new e-filing system, as it relates to candidates and personal, and independent committees and PACs and ballot committees, as well as personal financial disclosure statements, will roll live January 1 of 2021 to sort of seamlessly integrate to the next election cycle. The lobbyist filing system, because of some things we've had to juggle and move around budgetary, that will not go live until August of 2021. And so in that interim, they will still be filing into what we call the legacy filing systems. This is going to involve training with staff and the tech company, and then involve training with staff and elected officials, and, we'll put together some of those educational webinars that we do, potentially even in person if it's at some point safe to do that. We're also going to be working with the tech company to work with these third-party groups that file on behalf of candidates. So there are a number of those organizations that can file directly into our system that we allow access. We'll be working with them before it rolls live in January, so that everyone is sort of integrated into this new filing system. And it's going to be a big improvement from what we have now. We're working basically on iPod technology. If you look at when this was implemented, this will be much more automated, and it will allow us to much more efficiently investigate some cases. And I'll use Ms. Norwood's case as an example, because that's now closed. And I didn't say earlier, but credit to Mr. Lane for a lot of hard work on that in helping us get that ready. But we had to hand tabulate thousands and thousands of pages of contributions because we didn't have that feature or ability to automate it. We can do that now better with some things that this will implement, as well as automate reminders to people that they have filing deadlines coming up instead of having to do that manually. The other really important thing I wanted to talk about, and we talked about this at the last commission meeting, was the fiscal year budget. Initially, at that point, there was a proposed budget. I don't believe the House and Senate had gone into conference caucus yet, but it was looking at an 11% cut to the state agency. Working with the House and Senate, working with both parties, we were able to get that reduction all the way down to a little more than 5%. So we have now been able to avoid furloughs of any kind. We've not had to let any employees go. We actually were able to restore some funding to fill some open positions that we were holding off on until we got clarity. And, hopefully we'll keep working with them and get some more money back so that we can, do more and more efficiently and effectively carry out the mission of the agency. But I am happy to say that we were able to work that budget cut down significantly, and, no one's missing a paycheck. Very briefly, the last thing. Last December, I talked briefly about a formal record retention policy that we were going to implement that would be consistent with other state agency and state requirements. We've done that. This is just a mechanism to make sure we're keeping all the records as long as the state recommends, but at some point, we're not just filling up, filing cabinets and taking up space for 20-year-old cases that we can digitize and then shred. So, happy to say we finished that. Mr. Chairman, that's all I have.
Okay, well, good. Well, that's exciting on the filing system. That's one of the most frequent comments I get from the people that we regulate, which is, when are you getting a new filing system? So good. So thank you. Next is the report of the Attorney General. And I take it we don't need anything in executive session for this report?
No.
Okay. Go ahead, Mr. Fuller.
Thank you, Mr. Chair. Just two things. One, I have a hearing scheduled for this coming Monday at the Office of State Administrative Hearings in the matter of Sabrina McKenzie versus the Commission. I will tell the board members that we have been actively working to try and resolve the case. Efforts at this juncture do not seem to have beared much fruit. So I am prepared come this Monday, 9:30 a.m., the Office of State Administrative Hearings here in Atlanta, to move forward with an evidentiary hearing. Mr. Cusack is assisting me in that matter. So assuming the hearing goes forward, if any are curious to see how they unfold, you're more than welcome to attend. There's nothing spectacular, but we've talked about this before in the abstract, so it will become a reality for those who would like to attend. Secondly, I finally come bearing an Attorney General opinion.
It's like Christmas Eve, man. Gosh, who would have thought?
Right. I've emailed it to the executive secretary, Mr. Amati. There's a lot in here, and I don't necessarily want to try and summarize it for you guys without all of y'all having a chance to go through it, because there may be some policy implications that are beyond the scope of what we can opine on, if that makes sense. And so, for the most part, the opinion, I think, is in line with what the law requires, and some of the high points. Just as a general reminder, the main question that was asked was regarding when the commission is allowed to increase or decrease maximum contribution limits for certain election cycles. And there were 5 questions that were asked. One, whether the commission's regulation on adjusting contribution limits is consistent with statutory authority. 2, whether the commission is mandated to raise or lower contribution limits each year, or does it have discretion? 3, whether the commission may provide for retroactive campaign contribution increases, or must any changes be prospective only? 4, whether the commission can delegate its authority to increase contribution limits to its staff, or must only be authorized by the board. And then 5, whether contribution limits may be raised or lowered more than once during an election cycle. So the opinion answers all of those questions. In some, and again, there's a lot in here. I want the commission to review it, and if there are any specific questions after reviewing, I'll be happy to answer those at our next meeting. I think it might be best to leave it there, unless you want a brief. I can touch on a couple of points.
As far as adopting, do we need to take any formal action to adopt?
No, this is just merely an opinion on the current state of the law.
Okay. That's what I thought, yeah, send that to the commissioner, please.
Yeah.
Okay. And good work on, I know it takes, preparing for hearings is a lot of work, so good luck to you guys, and we appreciate you guys' hard work and making it happen.
Thank you. I don't know that this one is necessarily one to hang our hat on, but,
Some are tougher than others.
That's right.
Is she represented by counsel?
She is. And, well, I'll leave it at that.
Okay. Well, good. Well, thank you guys for that. We appreciate that report, Mr. Fuller. Okay, public comment. Anyone here to make public comment? We do have a special guest here. Vice Chairman Cranbule's daughter came in town. I think she got more fun out of watching me have to use the restroom earlier than anything. But we appreciate you coming too. Okay, well, that looks like that'll wrap it up, unless anyone has any new business or anything else. All right, well, I will make the motion to adjourn the meeting. So I can get a second. Yeah, we got a second. We got a motion and a second. Any discussion? Hearing none, I call the question. All in favor, say aye. Aye. All opposed? Aye. All right, motion carries. Enjoy Italy, Commissioner Thompson. Take pictures for us.